Good afternoon. Good afternoon, and welcome to Tuesday, July the 10th, convening of the Baltimore City Board of Municipal and Zoning Appeals. A couple of housekeeping rules before we get started. First, if you have a cell phone, a pager, or anything that makes any kind of audible, electronically generated sound, anything that plays a ringtone, a chime, beep, etc. We ask at a minimum you please turn those devices to a vibrate only, if not off position. Similarly, to the extent that you need to have a conversation with someone in the gallery, we ask that you please take those conversations out the double doors to your rear. And the reason for those rules is pretty simple and straightforward. You'll note that there are a number of microphones which are arrayed around us up here, and those microphones are all very sensitive. They're not only for the purpose of amplification, but also for the purpose of recording. Cell phones, pagers, conversations, generally noise emanating from the gallery disrupts not just the conduct of these proceedings, but also the recording of these proceedings. Additionally, those of you who are sitting forward of the wall above you, if you turn around, you'll see that there are 1, 2, 3 video cameras which are mounted on the wall up there behind you, and there are 1, 2 video cameras which are mounted on the wall up here behind us. Those video cameras are active and are streaming these proceedings on the website for the city's cable access network, as well as videotaping these proceedings for subsequent tape delay broadcast on said network, and recording these proceedings for posterity's sake on the city's YouTube channel. So again, cell phones, pagers, conversations, and the like generally disrupt that process as well. With that out of the way, we will be voting at the end of the day, and you are certainly more than welcome to hang around and enjoy a civics lesson if you so choose and want to find out how we ruled in your case. However, if you've got other plans for this midsummer's afternoon, you can call into the zoning board office in the morning and find out how we ruled on your case. If you take out pen and paper, I can read the number off for the zoning board office a couple of times. That number is 410-396-4301. Again, 410-396-4301. You will, however, need to wait until you receive the formal written notice of the outcome of your proceeding, which should be forthcoming in about 3 to 4 weeks. Before you'll be able to get your permit. We certainly ask that you please not build in the city of Baltimore without first obtaining all of your necessary permits. The procedure for our cases today is the same as it is for all of our hearing dates, and those of you who are unfamiliar with our procedures, I'll go through them for you. When the cases are called, you'll come forward. The appellant, if any, will stand, well, the appellant will stand to our left or your right. The opposition, if any, will stand to our right or your left. Once everyone is up here, we'll get you all sworn in, and then we'll first begin with the appellant, who'll be given the opportunity to present their side of things. Present their arguments, testimony, documents, and the like in support of their arguments, respond to any questions from the board, and generally inform us as to the issues involved in the case, and respond to any questions which we may have. Once the appellant is concluded their presentation, the opposition, if any, will be given their chance to do the same. That is, present their documents, witnesses, etc., in support of their arguments, and respond to any questions which the board may have as well. Once the opposition is concluded, we'll then turn back to the appellant and give them the opportunity to respond to any points brought up by the opposition, as well as to give them an opportunity to offer a closing statement. We won't be going back and forth and necessarily delaying things longer than is necessary. If you are in opposition to any case today, we ask that you please sign in on our sign-in sheet, which is being held up by Mr. French. The sign-in sheet not only allows us generally to know which cases have opposition, but also allows us to know who needs to receive those aforementioned written notices I was just talking about. So if you're here in opposition to any case today, please make sure that you've signed in on your sign-in sheet. In addition, we also do have some cases which are being postponed today, and if you are here on any of those cases, or in a case which subsequently may be postponed, we need to know who you are and how to contact you to let you know when those cases will be going forward if they do not go forward today. We'll be hearing the cases generally in the order in which they appear on our docket after we first address some preliminary matters. First issue, as I mentioned, is we have some postponements on our docket today. All of these cases are cases which will not be heard today, but which will be heard on subsequent dates. So please make sure that you listen up to make sure that that this is not any of your cases, or if it is, that you've signed in so that we know how to contact you to let you know when the cases will be going forward. Some of these cases have already been rescheduled, and I'll be reading off those dates for those cases as well. So if you're here on those, make sure that you get that information too. First case being postponed is 2018-127, 3205 Mardell Avenue. That case has been postponed till September the 18th. Next, 2018-160, 2113 West Lafayette Avenue. That case has been postponed. There is not currently a rescheduling, currently a rescheduled date for that. And finally, we have 2018-194, 2000 East 30th Street. That case has been postponed until July 24th. So if you hear on any of those cases, none of them will be going forward today. Just make sure that you signed in on our sign-in sheet so that we can let you know of any other matters which may arise in those cases. All right, next we have the cases which are on a consent agenda. And the consent agenda consists of cases where the staff has reviewed these files, and the board has determined that we have the ability to approve these cases on a consent basis based on the record assembled thus far. We're going to call all the consent cases together as a group. As I read them off, if you could come forward, the first person will stand right here behind that microphone. Everyone else will line up down the dais behind them. Please try to stay in the order in which you're called. Once everyone is up here, we'll get you all sworn in. And once we've done that, we'll call each case in turn. You'll be given the opportunity at that point to offer any further information that you would like to have added to the record at that time. First case on the consent agenda is 2017-298, 5715 Hillen Road, Paul Wheatley. Next, we also have 2017-328, 6727 Reisterstown Road, also Paul Wheatley. For that, we have 2018-146, 1428 Battery Avenue, Ray Rahuba. And then 2018-185, 2409 Reisterstown Road, Michael Jacobs. 2018-195, 3420 Ravenwood Avenue, Mike Feliciano. After that, 2018-196, 915 Cathedral Street, Estella Aspinwall. Okay. 2018-197, 513 Willow Avenue, Yvonne Gonzalez. After that, 2018-198, 6002 Wallace Avenue, Rena Urzoy. Then we'll have 2018-202, 1817 West Lombard Street, Laketta Davis. And then 2018-206, 1400 Mosher Street, Tayara Davis. And then we'll have 2018-207, 3301 through 3303 Eastern Avenue, Travis Bell. If all those intending to give testimony in these cases can raise their right hands to be sworn.
You swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, the first case on the consent agenda is 2017-298, 5715 Hillen Road. Paul Wheatley.
Yes. Thank you. Jennifer Bussey, Whiteford, Taylor, and Preston here for Mr. Whitley and for BGE and Exelon.
All right, and then we have this as, I guess we can deal with both of these cases together. You're also here on Reisterstown Road?
Yes.
Okay,
Thank you.
and that's 2017-328, 6727 Reisterstown Road. We have both of these as applications to construct new 83-foot tall poles with 8 antennas into existing BGE electrical substation for BGE use only. Is that correct?
Exactly.
All right. Mr. French, anything for the planning department?
Thank you. Martin French for the Baltimore City Planning Department. Planning Department has reviewed these applications. They were originally for poles to be 106 feet tall. The applications were actually filed last summer, and there's been an extensive and very intensive process of discussing the effect of these particular poles upon the communities. The applicant has worked with us and also with the communities to reduce their impact. On that basis, the Department of Planning recommends that approval of the application be subject to these conditions. Where visible above the walls of the existing electrical distribution substation, the antennas and related equipment must be painted to minimize their visibility to ensure they are as visually unobtrusive as possible. The panel antennas and related equipment will remain as mounted, mounted as illustrated in the plans and elevations submitted to planning, and the applicant will adequately mitigate any adverse effect as specified in the report of the Historical and Architectural Preservation Division of the Department of Planning in accordance with that report's recommendations. Thank you.
Thank you. And ma'am, are those conditions offered by the planning department acceptable to your client?
Yes.
Okay, and is there anything further you would like to have added to the record at this time?
Yes, please, just very briefly. Thank you. It's been a pleasure to work not only with Mr. French, but with everyone at the planning office as well. I do have here, if anyone did have any questions, as I said, someone from Exelon and BGE, and as well, Mr. Barry's been a huge help to the team. Briefly, since we expect we may be back in front of you for one more site, I just wanted to explain, we were in front of you, it was probably almost a year ago now, for 2 other sites that were also on the consent agendas, and those went well. Basically, what's going on is system-wide, BGE is upgrading its internal communication system, and that means that over the entire service area, there's about 95 substations at which they will be using those properties to, in this case, for example, put in these poles that assist them with the communication back to their central hubs. In the city, there's about 9 to 10. We already have approval for a couple of them. Many of them were allowed by right. So again, if you had any questions, we're here to answer them, but it's been a pleasure, and thank you very much.
Thank you. Anything further?
No, I think that does it.
All right. So Neighborhood staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeals.
Thank you. I do have a few documents I want to just put in the file to make
That'll
sure.
be fine.
Should I give those to Mr. French? Or?
Sure.
Okay.
Actually, if you can give them to Mr. Baumgartner.
Okay. Thank you again.
Thank you. Next, 2018-146, 1428 Battery Avenue, Ray Rahuba.
Afternoon.
Afternoon, sir. We have this as an application to construct second floor, rear, and rooftop decks at this location. Is that correct?
No.
Okay.
The reason being, per the application, the correct address is 1429 Battery Avenue,
Okay.
which I would like to do the described deck there. Just correct the address, please.
Okay. All right, so that would be to construct second floor and rooftop decks at 1429 Battery Avenue.
Correct.
All right. Mr. French, anything from the planning department?
Planning Department has no comment on this application. Thank you.
Thank you. Okay, and Mr. Rahuba, anything further you would like to offer into the record in this case?
The only thing I would add is this is one of the few properties on that block that actually does not have a 2-story deck, so it would be in characteristic with the neighborhood.
Mm-hmm.
That would be the only thing I would add.
Okay. Anything further?
No, sir.
All right. The zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal. Good luck.
Thank you.
Take care. Next, 2018-185, 2409 Reisterstown Road, Michael Jacobs.
Hi, I would like permission to zoning in order to open up a business store, a jewelry shop.
Yes, I was going to say, sir, we have this as an application, we have this described as an application to use the first floor as a jewelry store. Is that correct? Okay. Mr. French, anything for the planning department?
Planning Department has reviewed this application and has no objection. Thank you.
Okay. And Mr. Jacobs, was there anything further you would like to add to place in the record?
No.
No? Okay. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Good luck. All right, 2018-195, 3420 Ravenwood Avenue, Mike Feliciano. Okay. 2018-196, 915 Cathedral Street, Estella Aspinwall.
Good afternoon, sir. May I ask that my daughter talk instead of me?
Yes, that's fine.
Thank you.
She was nervous. Hello, yes.
State your name for the record, ma'am.
Maria Teresa Aspinwall, her daughter.
Okay, and Ms. Aspinwall, would you please raise your right hand to be sworn?
Yes.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. Ms. Aspinwall, we have this application described as an application to use the premises for 4 dwelling units. Is that correct?
That's correct.
Mr. French, anything for the planning department?
Yes, Planning Department reviewed this application, noted that this property is located in the Mount Vernon Historic District, and recommends approval of the application. The applicant has worked with the department staff to resolve this matter. Thank you.
Thank you. And Ms. Aspinwall, is there anything further you would like to add to supplement the record in this case?
No, don't.
All right.
Thank you for the review, yeah.
Okay. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve your appeal.
Thank you very much.
Take care. Good
Okay,
luck.
good luck.
Next, 2018-197, 513 Willow Avenue, Ivan Gonzalez. Afternoon, folks. Your names for the record?
Dave Caravan.
Okay, and ma'am?
Olayinka Oladapo,
Okay. Yeah, can you spell your name again, ma'am?
Olayinka, last name Oladapo.
All right, and we have this described as an application to construct a second floor rear addition at this location. Is that correct, sir?
That's correct.
All right. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
All right, and anything further from either party as to supplement the record in this case?
No.
No? Okay. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve the appeal. Good luck to you both.
Thank you, sir.
Thank you.
Next, 2018-198, 6002 Wallace Avenue, Rena Urzoy.
Hello, how are you?
Hello. Ma'am, we have this as an application to construct a 2-story rear addition at this location. Is that correct?
It's, I was told it's technically a 1-story. I don't know if that makes a difference between 2-story, 1-story with a basement and a first floor. So I don't know if that's a,
Okay. I don't think that it really makes functionally a difference for our purposes here, but you're saying that it's just an addition to the
rear of the house. Yes.
the first floor rear of the house?
Yes.
Okay, and there's not an additional floor that's above it that's being altered or anything like that? No? Okay. Yeah, that would be 1 story. All right, Mr. French,
Planning Department has no comment on this application. Thank you.
thank you. And Ms. Urzoy, did you have anything else you wanted to add to supplement the record in your case?
That's it.
That's it? Okay. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve your appeal.
Thank you so much.
Good luck to you. 2018-202, 1817 West Lombard Street, Laketta Davis.
Yes.
Afternoon, ma'am.
Good afternoon.
We have this as an application to use the first floor as a thrift store. Is that correct?
Yes.
All right. Mr. French, anything for the planning department?
Yes, Planning Department has reviewed this application and recommends approval. Thank you.
Thank you. And Ms. Davis, was there anything further you would like to add to supplement the record in your case?
No.
All right. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve the appeal. Good luck.
Thank you.
Take care. And 2018-206, 1400 Mosher Street, Tayara Davis.
How you doing?
Afternoon, ma'am. We have this as a application to use the first floor as a beauty shop. Is that correct?
Yes.
Okay. Just a moment. Mr. French, anything for the planning department?
Yes, Yes, thank you. Planning Department reviewed this application and recommends approval. Thank you.
Thank you. And Ms. Davis, is there anything further you would like to add to supplement the record in your case?
Only that I made myself a petition and walked around the community, and I got some signatures that I just want to keep in my file from the support of the community.
Okay, would you like to hand those up? And would you like these to be placed into the record? Or-
Yes.
Yes, okay. Anything further?
No.
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank
Luck to
you. All right.
And last but not least, 2018-207, 3301 through 3303 Eastern Avenue, Travis Bell.
Good afternoon.
Afternoon, sir. We have this an application to use a portion of the third floor for coffee roasting for wholesale. Is that correct?
Correct.
All right.
I'd like to note that the address is just 3301, and it doesn't include the 3303.
Okay. Is this in a, like, is it in like a space in one large building?
Correct. So third floor, there's going to be a room spaced out that will have the roasting available in that space.
Okay. Then the reason I asked is that it may be the case that although your operation may be in the portion of the building known as 3301, if the building address is 3301 through 3303, that's the reason why that is.
Okay.
All right. Ms. French.
Planning Department has reviewed this application and recommends approval. Thank you.
Thank you. And Mr. Bell, is there anything further you'd like to add?
No, thank you.
Okay. Zoning board staff, having previously reviewed the application, we determined there is sufficient information to approve the appeal. Select you.
Thank you.
Okay. Now we're going to address the remainder of our docket, which will include cases where opposition is signed in. Frequently, we found that opposition is a result of either a lack of communication or miscommunication amongst the parties, and it can be useful to offer the parties an opportunity to have a dialogue amongst themselves to see if they can come to a resolution of whatever dispute they have. Obviously, if there are two sides engaged in a dispute in the matter, and they approach the board and ask the board to resolve their dispute, one of those two sides is bound to go away disappointed with the outcome, and this is your opportunity to avoid that unhappy fate. I'm going to call off the cases where opposition is signed in and ask if there has been discussion among the parties, or if the parties would like to have a discussion now or continue the discussions which they've already had. You can stand where you are. You're not obliged to take the opportunity to speak with one another, but we certainly do encourage and appreciate it. First case where opposition is signed in is 2018-150, 1823 Lancaster Street.
Herbert Burgunder here on behalf of the petitioners.
Okay.
David Schuster on behalf of the neighboring property owners, Craig and Anita Spillman.
Okay. And counsel, I'll imagine that there has been prior discussion amongst you in this case. Any desire to continue to see if you can work something out here?
Couldn't hurt to talk a few more minutes and see.
Okay. Just to let you know, since we have a number of, we don't really have that many cases which have opposition today, so we're probably just going to let everybody else play through. So we'll get through them first before we get to you, so you have a few minutes.
Thank you.
All right. And next we have 2018-204, 2558 West Pratt Street, Taisha Ruffin. Okay. And who signed in this case? You did? Okay. And folks, has there been any discussion between the parties?
No.
No? Would you like to have one now?
I don't know this young lady.
Well, you can
Good
talk
chance
to
to get to know her.
All I can say is I've been living where I live around the corner since 1976. There has been no store there.
Okay, well, that's fine, but
And
the law.
it comes
but-
to my back alley.
Okay, you just need to understand that the law may permit the kind of operation that's there now. The idea in having a discussion with the applicant now is so that A, you can meet one another, and B, see if you can't come to a resolution of whatever dispute you have. Maybe there are some accommodations you would like the applicant to make regarding trash pickup, security, et cetera. You're shaking your head,
Yes, sir.
but what I need to remind you of is that you might find that your opposition may be fruitless, in which case you would walk away with nothing. The opportunity to have a dialogue is to see if you can secure some sort of agreement where if the case doesn't go in your way, maybe you can work out something where you get some accommodation from the applicant by way of an agreement. As I said, you don't have to speak with her.
I don't mind
But-
speaking with her because I'm
Okay.
a nice person.
Okay.
But we can't work anything out, sir. I had to call the city 2 years in a row, 3-4 times to try to get that backyard cleaned up at that address. Nobody ever came to clean it up. I'm in the North Clean now. And I
Okay,
don't
okay,
back.
ma'am, I'm not interested in the merits of the case right now.
Okay,
I'm not.
well,
It's
I'm
just
not
an
interested in
it,
talking, so.
okay, have a seat. Okay, have a seat. Well, no, I'm not calling the case now. I'm calling the other cases, but I was
Have
just,
to wait?
yes, just have a seat. We'll call you in turn. All right, thanks. You can have a seat. All right. Okay, calling the first case, 2018-85, 848 North Utah Street, and 2018-116, 846 North Utah Street. Dino Lafiandra.
Good afternoon.
Afternoon, sir. All right, Mr. Lafiandra, we have the description for these appeals the same, which are applications to replace an existing single-faced rooftop general advertising sign with a digital general advertising sign. Is that correct?
That's correct.
All right. If all those intending to give testimony in this matter would raise their right hands to be sworn, please.
Swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes.
All right. And do we have staff reports?
Yes, thank you. Planning Department has reviewed this application, noted that there is a provision in the zoning code which is specifically subsection 17-603B, which prevents conversion of non-electronic or non-digital billboards to electronic or digital billboards unless the billboard owner simultaneously removes at least 3 non-electronic or electronic existing billboard faces at other locations. In this situation, the applicant did not file information concerning 3 billboard faces that would be removed in exchange for receiving approval to convert this existing billboard, which is non-electronic, to electronic use. The other factor at play in this particular situation is that this billboard happens to be at a very low level in relation to street level, and in particular, the line of sight of motorists approaching this intersection from the north. The typical billboard is on a monopole on the order of 40 to 50 feet high. This particular billboard is placed on the roof of a 1-story building and affixed to the wall of a 2-story building that adjoins that 1-story building, and therefore, in fact, is quite low. The department is concerned that this new large bright light source, which would be created by LED display of images on this billboard, would also be a concern both to neighbors of this property and specifically that anybody attempting to sleep in any private dwellings in this vicinity might be affected by that light display. The department recommends disapproval of the application due to the low height and placement of this billboard on the property and the close proximity to the surrounding properties, which together create a greater impact on the surrounding community as compared to billboards in other locations. Additionally, as the board weighs this application and the merits of it, the applicant should provide documentation of at least 3 existing billboard faces that have been or would be removed if the proposed digital billboard would be approved. Thank you.
Thank you. All right. Mr. Lafiandra, I guess it'd be appropriate to ask if you have a response to the position articulated by the Department of Planning.
Yes, sir. At the outset, I'd like to take issue with the provision of law that the Department of Planning is pointing your attention to. If I may, I'd like to just hand out some sections of the code. I'm sure that you're familiar with them. The Department of Planning refers to Section 17-603, which does provide that this governs new billboards. Right by its terms, it says, except as otherwise specifically provided in this code, the erection, placement, or construction of new billboards is prohibited, and the city may not issue permits for these signs. And then subsection B, of course, contains exceptions to that general prohibition. B2, as you can see, applies to new paper billboards, and B3 applies to new digital billboards. Neither of these two, none of these provisions, the general prohibition or B2 or B3, deals with existing non-conforming billboards. There is a provision of law, which I've included in this handout, which deals with, this is in the current code, non-conforming billboards. This is the next page. If you're following on page 2, which actually at the bottom of the page is page 409, this is section 18-504. Any change to a non-conforming billboard requires the approval of the Board of Municipal and Zoning Appeals. And section B of that particular section contains the required findings that the board needs to make in order to authorize modifications to existing non-conforming billboards. The Department of Planning omitted any reference to 18-504 in its comment as it relates to this particular billboard, despite the fact that the application stated that it was a non-conforming billboard. I would also point out that that this first section, 17603, as it relates to new digital billboards and new billboards in general, was a recodification in the 2016 recodification of the zoning code. This was a recodification of former section 11206 of the old code, which I've also included, and you'll see that if you continue to turn the page. If you're following along, this is the page, at the bottom of the page it says 310, and it has the date of December 24th, 2015. 11206, this is from the old code, and it contains exactly the same language as 17603, except 17603 has these exceptions, which were not in the earlier version of the general prohibition on billboards in 11206. But also, the important thing to note here is the old code also had a provision that dealt with non-conforming general advertising signs, non-conforming billboards. And I included that as well. That's the last page of the handout. That's section 11506, which states, this is from the old code, and this is the section of law that the board has always authorized modifications to billboards. In fact, the board has authorized conversion of paper billboards to digital billboards under this section of code in the past. And this section...
Under the prior code?
Yes, it is. And this language was adopted word for word into section 18504, which is on page 2. So those are, that is, although it is the prior code, it was adopted virtually identically into the new code, and there's no indication that there was anything other than the prohibited additions and alterations, which were also in both the old code and the new code. These are the only things that the board may not authorize as additions or modifications to non-conforming billboards set forth in the code. Internally illuminated illuminated box signs, neon signs, tri-vision signs, or fluctuating signs other than for time or temperature. That language is in both the old code, under which the board has authorized conversion of digital billboards, and in the new code. For those reasons, we disagree with the position of the Department of Planning, which says that 17603 prohibits the conversion of paper billboards to digital billboards. In fact, non-conforming paper billboards may be modified by the terms of 18504 to digital, provided that the other findings and conditions are met. And I've got witnesses here which are going to make those points.
All right. And we were aware of the provisions of 18504 and the apparent conflict with 17603.
Yes, sir.
One thing that, as you were going through your presentation, I was looking at, which neither planning nor you addressed, is 18502. Talks about alterations, replacements, relocations, etc. Says any non-conforming sign may be structurally altered, reconstructed, replaced, or relocated as long as the alteration, reconstruction, replacement, or relocation does not result in, and you go down to 3, the addition of any moving, rotating, or otherwise animated part, or any flashing, blinking, fluctuating, or otherwise animated light. And when I looked at the definition of sign, this is in
You'll forgive me, I don't have that section.
313. I'm sorry?
I don't have that particular section, the definition of
read it off
sign.
to you.
Yes, thanks.
Section 313J, this is 1, in general, sign means any writing, including letter, word, or numerical, pictorial representation, including illustration or graphic, emblem, including logo, symbol, or trademark, flag, including banner, pennant, device, or any other figure of similar character that is attached to, painted on, or in any other way represented on a structure in or on a window, or on the ground, is used to direct attention or advertise and is visible from outside a structure. And then it says a sign does not include murals or other art that contains no commercial message. So the question I have is, does that prohibition here come into play?
If I may,
in this case? Sure.
I do. I think it does come into play. And in fact, on 18504 required findings, this is 18504B. Pardon me, C. Prohibited additions or alterations, you see that virtually the same you may not, the board may not authorize the additions or modifications that would create an illuminated box sign or fluctuating signs other than for time or temperature. I would also mention that as it relates to 17603, which I handed out, it's on the front page of what my handout, 17603B3 contains 5 standards for new digital signs that are installed pursuant to that section of code, which prohibit animation, streaming video, images that move or give the appearance of movement, and other things like that. And although our position is that this provision of code does not apply, my witness will indicate that our digital sign will meet those requirements. So we are, I think that the point that you made as it relates to 18502.3 with the moving and rotating and animated parts and the blinking and flashing and fluctuating signs, that is reiterated in 504 and also in 17603.3.2, and we've got you covered every way that you can possibly go. My witnesses will testify to that.
Okay. Why don't you have them testify?
Okay, very well. Thank you very much. Mr. Cohen, would you introduce yourself?
I'm Richard Cohen. I am one of the owners of the company that owns the sign at the location.
You own the property, is that right?
I own the
You
property.
you're one of the
Both.
owners of the property?
Correct.
Okay. And how long have you owned the property?
Since at least,
You can say Mr. Lafayette.
Yeah.
Oh, pardon me, I'm sorry.
since at least 2011.
And where on these properties is the billboard located?
It's on the top roof line of 846 along the wall of 848.
Now,
It kind of in straddling the two properties.
do you, just for, Mr. Chairman, I have an exhibit that I'd like to.
We'll say we do have pictures of it.
Oh, this is the one that I would point your attention to.
I think we have that one too.
Yes.
All right.
Thank you. With reference to, let's call that Exhibit 1, and with reference to Exhibit 1, this photograph that's on the exhibit, can you describe what this shows?
It's a picture of the building and the sign.
And this is where you were indicating where the sign is located on top of 846?
Exactly.
And on the side of 848?
Yes.
Okay, very well. How large is the billboard that's currently there?
It's 14 by 48.
And how do you know that it's 14 by 48?
We had it measured by architect.
And
So that's 14 by what?
48.
Okay, our drawing shows 14.2 by 44.6.
That's it.
pardon me, let me clarify, I do apologize for that. Since the time of the submitting of the application, we did have an architect measure it, and the actual size is 14 by 48. And just to be clear, I will submit this then.
Sure.
Thank you very much. That'll be Exhibit 2. Would you like one for everybody?
No, it's fine. The only change is just
That was the only change.
measurement.
That's correct. How long has that billboard been on that property? Or has there been a billboard on the property?
Since 1955,
And how,
least.
go ahead.
at least.
And how do you know that?
It's on the zoning card, and upon settlement, we got a letter talking about it, dated in 1955.
Let me show you, this will be Exhibit 2. Is this the zoning card that you were referring to?
Yes.
Yeah. Mr. Chairman? Copy of the zoning card. And it's the top zoning card. You can see that it's dated July 12th, 1955, repair existing billboard. And is this the letter that you were referring to?
Yes, sir.
And can you characterize this letter? Do you know, understand what this letter says?
Yeah, at the time, they were going to get, they were doing a repair to the sign, and, I'm sorry. Okay. They needed to remove the sign for a reason, and the city assured them that it would be fine if they removed it, that the no permit would be, it would still be there, the space for the sign.
Okay.
At that time.
And so what's the date on this here letter?
This is from 2004.
Okay. And who wrote this letter?
This is Michael Savino,
And he was?
the superintendent, zoning administrator, and enforcement at the time.
Why are you proposing to replace the existing paper billboard with a digital billboard?
These are, there's a few reasons. First of all, safety, okay? To climb up there and is kind of, it can create an issue. Walk around the roof and there's furnaces everywhere. This is a big deal. Honestly, this is the way of the future. In my opinion, you're probably going to be getting a lot of cases like this. This is an amazing piece of technology beyond safety. They're efficient. They serve their cause. It's just a better sign. By all means,
Will the height or size of the sign change from what is there now?
not at all.
And will the sign be located within 10 feet of its current location?
Yes.
And will there be an internally illuminated light box?
No.
Will there be a neon sign?
Nope.
Will there be a tri-vision sign?
Nope.
Will there be any fluctuating sign or fluctuation animation moving part of the sign or part of the sign that appears to be moving?
None.
Will each message or image be depicted for at least 10 seconds?
Yes.
And will there be any glare directly onto residential premises or that interfere with the safe movement of traffic?
Nope.
Is there any residential property or premises in front of this particular sign?
No.
Where does this sign, what is in front of this sign?
There's a parking garage, there's MLK, there's a traffic light, I mean, it's the Estat State Building, it's the central business district.
This is across the street from the state office building?
Yeah. High density.
Will there be ambient light sensors to adjust the brightness of the sign in different lighting conditions?
Yes, there will.
And is there any audio component to the sign?
None.
Okay, thank you. Do you have any questions for my witness?
No.
I would ask Mr. Barry to testify. I know that Mr. Barry has testified before you many times on a variety of matters. For the record, in this case, I'd like him to just introduce himself for the record, because I'd like to offer him as an expert in planning and zoning in Baltimore City.
Okay. I think that we're familiar with him, and it's unopposed appeal apart from the position of the planning department here, so I think we can dispense with that.
Thank you. Mr. Barry, do you agree, have you had an opportunity to review the Department of Planning's comments in these cases?
Yes, I have.
Do you agree with the Department of Planning's legal analysis that this application should be analyzed under 17603? Yes or no?
No, it's the wrong section, and I can explain that in the context of the adoption of Transform Baltimore. I have with me a introductory copy of Transform Baltimore that showed that the adoption that was just presented to you under final passage was the same as the bill that was introduced under Transform Baltimore as prepared by the Planning Department. It would not make, in my mind, any sense to, if they were so interested in not allowing any alterations of existing billboards, to not propose that section in the original introductory version of the bill, which was in 2012, I believe. So really the standard is on its face is section 18504.
Okay, and you're saying that given that the initially proposed bill contained the exact same language now as it, contained the exact same language then as it does now, evidence is that there wasn't any desire to change the language or to modify it in any way to make it capture existing billboards or to clarify that it would attach to any kind of modification situation.
That would be my presumption. It's followed the adoption from the Planning Department to the Planning Commission to the City Council. This remained unchanged from introduction to passage, and I think it reads what it reads on its face.
Have you, Meg? Have you had an opportunity to look at the section that I've been talking about, 18504?
Yes.
And does that mirror the manner in which the board has previously authorized modifications to existing non-conforming billboards?
Yes, ones that I've been personally involved in, as well as ones that have been done by other applicants.
You heard the Department of Planning's comments about the safety of the location of this particular billboard with regard to traffic in the area?
Yes, I did.
And have you been to the location of this billboard?
Been to the location several times, different times of the day. It is as many of the members, maybe all the members of the board realize, it is a slow-moving intersection in traffic with MLK intersecting Utah. There's a light at MLK in Utah. It is slow-moving. I actually would disagree with planning's analysis of the safety aspect, because actually the lowness of this sign, it really puts it almost at eye level for a car, as opposed to a sign, as Mr. French pointed out, could be 50 or 60 feet in the air, which is not in your line of sight, looking ahead at where you need to look ahead at. So I think in many respects, it would be safer to have a lower sign in this location and something you had to look up at, frankly. It is not blocking any of the traffic signals. It does not face any residential properties. It's a well-lit intersection facing the back of the state office complex. So that comment in and of itself is the glare is going to affect residential properties. I think the ones that are on Utah Street would not even see it because they're pointed away from the sign, and the other ones that might be further down in MLK are 700 feet or more away. So there's no impact other than on the state office workers that might be working late at night.
And you mentioned, I just wanted to point out, the nearest residential use is how far did you?
Well, the ones that are on Emma would be 700 feet away, and the other ones on Utah are really behind it. So they're not going to be able to see this sign or the glare in and of itself.
And then, in your opinion, can this billboard be converted to digital in compliance with 18504?
Yes. I would argue that it would meet the standards of 18504, should the board approve it. And in many ways, one can look at this sign, if you've seen the picture, it almost functions as a mural. You know, unlike freestanding billboards on monopoles or structures extending above roof lines, this is something that's built essentially into the side of a blank wall. And in some cases, from an aesthetic standpoint, it really more fits in with the design of the building behind it than it would if it was on a freestanding pole hovering above the buildings.
Did any board members have any questions for the witness?
Sure. Did you have one, Jay? All right. Jay?
So the intent is to have a digitized billboard, correct?
Yes.
And would that be for the purpose of advertising, right?
Yes.
Do you have a list or an identification of what advertising you're going to be doing at this point? For example, do you have 4 or 5 companies who have contacted you and said, this is what we want you to, this is what we want to put up?
The billboard is currently under lease to Clear Channel, who they will continue to have a lease for the billboard.
And so for the advertising that's going to go up that you envision, through Clear Channel or otherwise, to your knowledge and your expectation, is that all going to comply with 18502? 3?
Let me just take one quick look at it before I answer, but I believe the answer is yes.
In other words, there'd be no flashing, blinking, fluctuating, or otherwise?
Absolutely not. I would mention, because you asked about the advertising, that currently, and for, the sign is for the University of Maryland, which is right across the street. It's the downtown campus, the Midtown campus, the hospital. And although it could be another advertiser at any time, that it has been the University of Maryland, kind of acting as an identification sign for some time. And I'm looking at those provisions of code right now. Moving, rotating, animating parts, flashing, blinking, fluctuating. We will comply with all of this.
In the 10-second rule that plays.
Yes, and there is also, as I mentioned, in 17603, which we say does not apply, there are 5 standards that must be met for new digital billboards. That's on the front page of the handout. We will meet all of these requirements as well. 10 seconds for each message. There will animation or images that move or give appearance of movement are prohibited. There will not be any glare into residential premises or interfere with the safe movement of motor vehicles. We will have ambient light monitors, which will automatically adjust the brightness level based on ambient light conditions, and there will be no audio component.
Thank you.
Mr. French, was there anything you'd like to offer from the department?
Well, I'd say first, I'd just like to note for the record that it was a mischaracterization to state that the planning department is opposed to conversion of billboards to digital. That is not the situation. The second thing is, you've heard a great deal of testimony about how the billboard will operate. The key point that the planning department considers in this situation is that there has been no offer to take down 3 billboards in exchange for conditional use approval of this billboard as a digital billboard. The appeals to which one of the people testified were appeals that were filed at the time the old code was in effect, and the requirement to remove 3 digital billboards in exchange for the approval of 1 was not in effect at the time those appeals were filed, and therefore there was no requirement needed to be imposed for taking down 3. The department considers that probably the most important point in this, because if this was to be approved without the requirement that 3 billboards come down, then this will set a precedent throughout the city for conversion of billboards to digital without reference to the requirement that 3 come down, as mentioned in Section 17603 of the zoning code. The planning department considers 17603 basically to be a subset, if you'd like to look at it that way, of the general requirements contained in the other sections of the code referred to by the people who've just been testifying. Thank you.
I'm not sure what you meant by that last comment. I mean, my question to you was, how do you square 18504 with 17603? I mean, I think there's a presumption that the drafters of the legislation didn't intentionally draft conflicting statements, maybe, for the code. So, I mean, is it possible that 18504 relates to modifications of billboards as opposed to 17603 relates to the construction of new billboards?
A great deal in the opinion I'm going to give you turns on the reading of the wording, subject to conditional use approval, a digital billboard may be erected. That is in 17603B3. If by erected you take it to mean a brand new billboard at a brand new location, that obviously has one implication for your decision. If, on the other hand, you mean a substitution of a digital billboard for an existing non-digital billboard, that has a completely different implication for your decision. And the planning department is not going to offer a recommendation on that point. That is going to be for the board to decide.
How physically will this transformation be accomplished? I mean, do you actually take the billboard down, the paper billboard, and rebuild?
The whole structure will come down for a short period of time, and they will put up a new digital billboard. They'll replace the structure.
So how is that not an erection?
It is it's a replacement.
Oh.
It's a replacement of an existing billboard. And to get to your point, sir, about the context of this particular provision, 17603, the Department of Planning would have you ignore the words new that occur several times in 17603 as it relates to 17603A, 1, 17603B, 2, subject to conditional use approval, 1 or more new billboards may be erected or placed on a publicly owned stadium, blah, blah, blah. But, and in the context of this section, both within the 4 corners of the section and where it came from, which I gave you, and that is 11206, which is the second to last page, it's page 310, with the date of December 24, 2015. This is the general prohibition on billboards, 11206, which was then expanded to allow certain new billboards, but none of those provisions dealt with modifications of existing non-conforming billboards.
And council, I've been sort of turning this over in my head, and then also response to one of the observations by Mr. French for the Department of Planning regarding this provision being a subset of the more general provisions. As Mr. Bonaventure said, we have to assume that the drafters of the code didn't intentionally set up a contradiction within the code. And there's some ambiguity here given the seemingly conflicting provisions of the code, and further resort to rules of statutory interpretation. You have to follow the specific over the general. And as I went through the two provisions we've been talking about here, 17603 and then 18504 and even 18502, I noticed something, which is that both of the sections speak generally to billboards, whether changes to billboards or new billboards, etc. But the language of 18603B3 is different in that it is particular to digital billboards. No other provision refers to digital billboards. They only refer to generally billboards. This seemingly is a specific condition that's being applied as to digital billboards specifically, and the erection of digital billboards. And the requirement there is that that there must be at least 3 existing billboard faces have been removed for each new digital billboard face to be placed or erected. So how do we deal then with the tension there regarding that rather specific language and the more general language that you've thus far relied upon?
Sure. 17603B2 deals with
Stadiums.
Stadiums.
And arenas. We're not talking about those here, right?
That's right, but the word digital is used there because it changes the ratio. If you've got a digital billboard, you need to give up. If you have a new digital billboard, you need to turn in 3 existing billboard faces. If it is not a new digital billboard, if it is a new billboard of a different type, doesn't say what other type, just says a new billboard, then the ratio is 1-to-1. The modifier digital only operates to bring you into that section where it has a
that
new.
only deals with erection or placement of billboards on publicly owned stadiums and arenas. So that's like all those billboards that are on the Royal Farms Arena, or that might be on any of the other stadiums downtown. So that's not in
Yes.
play here.
I understand the point that you're making, but I do think that digital does,
18.
if you've got a new digital billboard, then if you've got a different ratio than if you've got a billboard of a different description that would come into section 2 there.
Well, 17603B3 is the only one that speaks to, of any of these provisions, is the only one that speaks specifically to digital billboards. That language of digital billboard isn't found either in the general prohibition section discussing placement of new billboards. It's not found in 18502 in the discussion regarding signs or non-conforming signs. It's not in 18504 dealing with changes to billboards. Those all are general provisions which apply. And the only one that specifically mentioned digital billboards is 17603B3. And as I said, I think that the rule for statutory interpretation is that we have to follow the specific provision over the general.
Yes, and the specific provision here would be 18504 because we have a non-conforming billboard, which is established by both the zoning summary card from 1955 and the letter from Mr. Savino from 2004, which establishes that it's a non-conforming billboard. It's been there. So that's why you come under this whole section, subtitle 5 of non-conforming and changes to billboards. That's how you get to this section. This is the exact word-for-word section of code under which the board has authorized modifications and conversions of paper billboards to digital prior to now. Mr. Bonaventure, I'd also mention the letter from 2004, getting to your point, mentions reconstructing an existing sign. So I would say that it's not erecting a sign, it's reconstructing an existing sign.
And I don't think this has been brought up, but I'd just like your take on that. 18502-2 talks about an increase in the degree of illumination of the sign. So we're going to go from, there is going to be an increase because we're going from 0 illumination to some degree of illumination.
I mean, it's lit up, it's already illuminated.
It's illuminated now?
Yeah.
Is there going to be an increase in the amount of illumination then?
It doesn't have to be. We can control the light source on it and dim it all the way down.
There'll be an ambient light sensor which will adjust the illumination to control for
We'd
the
be willing to
the different lighting conditions.
Well, the light sensor typically would make it brighter at night and
No,
lighter
dimmer,
during the day.
dimmer at night.
It needs to be brighter during the day so that you can see it.
Yeah. So you would commit to be in accordance with 18502-2?
Absolutely.
Yes.
E- 18502, 18504, and 17603, we would agree to any of those. That's our plan as it is. It's not a matter of agreeing to it. That's what the plan is. But to be clear, we would agree to it.
Just not the exchange of 3 to 1.
We don't have 3 to exchange. And we think that a fair reading of the code takes us into 18504. And I think Mr. Barry was correct. This has far-reaching implications for the board. And I think the board needs to realize that these digital billboards are the way of the future, and there has to be some manner in which the city has control over it. I mean, for the board to say that you don't have any authority to digitalize these signs, it seems like it doesn't seem what was intended by the code, and it doesn't seem like, as a matter of public policy, what the board should do. You should retain some degree of oversight on these boards.
We're not saying we can't approve the digitalization, we're just not sure where we are on the 3-to-1 exchange.
Sure.
I mean, even that prohibition being, or that exchange being in there would suggest that there's a desire on the part of the mayor and city council to see a decrease in the number of boards.
No doubt.
So,
but I think that we are bound to the words of, just as you indicated earlier, we're bound to the words of the statute. There were clearer ways for them to say that under all circumstances you need to turn in 3 if you want to put up 1.
correct. And so the situation we find ourselves in is that we've got wording that's not clear, which lends itself to concluding that it's ambiguous. You know, we're dealing it when it talks about new billboards. Does that?
I don't think it's as ambiguous as
here.
My witness is trying very hard to make a statement here.
I'm sure he is. There might even be others in the gallery who'd want to jump up too. But yeah, I think that the implication from the drafters of the code is that they want to see a decrease in the number of overall boards, and yet there's a lack of clarity in the language, which, as I said, lends itself to concluding that it's ambiguous, so we now have to sort of resort to rules of interpretation as opposed to simply applying what's written.
I don't think it's as ambiguous as you do. I think if you look at it, the 17 section deals with new billboards. 18 section deals with non-conforming uses. I don't see it as ambiguous.
Well, I
but
guess that's the question, one of the questions. I mean, if you tear something down and rebuild, isn't it new?
pardon me, I'm sorry.
That's okay. If you tear something down, that was the reason I asked that question earlier. If you tear something down and rebuild, isn't it new?
There is in the law of nonconforming uses, you can take something down to replace it. That does not constitute abandoning it. If your intent, you need to intend to abandon it. And if you don't intend to abandon it, then you haven't abandoned it.
Well,
As long as you otherwise comply with the code, you can't take it down for more than a year or whatever the code section
I understand
provides.
that. But if you intend to abandon a paper sign, you tear it down and you're abandoning that paper sign.
Yeah, they would not, and in fact, if you look at the letter from 2004, they had sought this letter specifically because they needed to take it down for a period of time to, if the renovation of your structure requires the temporary removal of the sign, the city's zoning office acknowledges that you have no intention to abandon the use and will issue the necessary permits to rebuild the sign at the size that was previously approved.
Well, that was under a different regime. I mean, at the time then, it was, the only issue was the one that you were just talking about with continuation of
Yes.
non-conforming uses. Everyone knows that non-conforming uses are allowed to continue so long as they're not abandoned. That letter just clarifies that, yes, under the then existing regime, if you were just taking it down to rebuild it, you weren't abandoning.
That's
or
all I was
creating
offering
a
it
new
for,
use.
yeah.
But I think that what Mr. Bonaventure's point is that there's a question under the code now whether the language is drafted includes includes as new the reconstruction of not really the reconstruction, I guess it'd really be the destruction of a pre-existing billboard and the erection of a new billboard of a different type.
This is the same way that the board has, these are all the exact same words that the board has operated under.
Under the old
Under
code.
the old code.
I know,
It's
I
the
got that.
exact same words.
I got it.
With the exception of the provision that allows new digital billboards where there was no provision of, or stadium billboards, where that provision was not in the code before.
That's correct.
Otherwise-
They put that in there, and it's the only one that deals with digital billboards, which is why I latched onto that language, because as I'm just kind of turning this over and trying to follow along, that's when I noticed the fact that that's the only place where they specifically refer to digital billboards.
That was a new area of permission. It was just a new area of permission.
That's correct. And they
Yes.
were dealing
There's
with it. The change, though, was that from the former situation where we dealt with these as simply modifications to non-conforming uses. So you take it down, you build it up, you're not abandoning it, you're modifying it, there are some restrictions on that. As long as you follow those, you're fine. But then the council puts in this provision, as you said, and they specifically say, well, with this situation with digital billboards, this is what we want you to do now.
That's correct, except that 17 only deals with new digital billboards.
Aren't we
18,
dealing with a new digital billboard here?
no, 18 deals with modifications to non-conforming billboards.
But this is a new digital billboard.
It's a non-conforming billboard. It's a non-conforming general advertising sign.
Generally, that's correct.
Yes.
Generally it is, but the specific use and the specific language here is digital billboard.
I think in the parlance of zoning, I think the term new would mean a new use as opposed to an existing non-conforming use.
Mr. Chairman, I can point the board's attention to 18504D, supporting structure. The Board of Municipal and Zoning Appeals may approve a change in the sign supporting structure.
Mm-hmm.
That's the current law.
Yes.
Yes.
Okay. Any other questions?
What?
Okay.
All right. Thank you very much.
Thank you, gentlemen.
Thank you.
Thank you very much for your time.
Thank you.
Was there any other opposition to this?
I believe Well, we can talk about that when we go through it, but I believe that we have some in the file. Let's go to 2018-199, 1928 McCullough Street, Timon Smoot. All right, you're Mr. Smoot?
Yes, sir.
All right. And Mr. Smoot, we have this an application to use the premises as 4 dwelling units. Is that correct?
Yes, sir.
All right. Sir, would you raise your right hand to be sworn?
I do swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right. And do we have staff reports?
Thank you. Planning Department has reviewed this application, noted that this property was at one time authorized for use as 4 dwelling units, a multifamily dwelling, by an appeal back in 2009. However, no use and occupancy permit for 4 dwelling units was issued timely, and that approval has lapsed. Therefore, basically, the applicant is approaching this as a conversion in this particular zoning district, R8. However, given the fact that there were 4 dwelling units, the department notes that there is a requirement for a lot area, which is insufficient in this case, and then a variance of 17.8% by the department's calculations is required for approval of 4 dwelling units. The department also notes that this particular property can only provide 2 dwelling units in the rear yard for the 4 dwelling units proposed.
I mean, 2 parking spaces.
I'm sorry, 2, thank you. Thank you for the correction. 2 parking spaces for the 4 dwelling units proposed. The department therefore recommends that approval of the application, if it is granted, be subject to the condition that 2 off-street parking spaces are provided in the rear yard of this property. Thank you.
Okay. All right, Mr. Smoot. I guess first, as to the Department of Planning's requested condition regarding the availability of a parking space in the rear.
Yes.
Are you able to provide that? It shows that, I guess, it shows in your drawing that there's a parking area.
Yes.
Along with a concrete pad, 17 feet by 49 is what is shown as a parking area in your drawings?
Yes.
Okay. And you're fine with making that available for at least 2 parking spaces?
Yes.
Okay. All right. And why don't you tell us a little bit more about what you're proposing here?
Well, I have 3 dwelling units existing at the moment, and I would like to add a 4th one as we're here for, but, I mean, I will be able to provide parking, and the square footage is meeting requirements for the 4th unit.
Okay, and this is going to be a basement unit?
Yes.
All right, and there's separate access?
Yes.
And what is that access?
Well, I have a access window going through the front for another exit point, and I have a rear door, so I have 2 exit points. Actually 3, but because you can come when you come down the basement, but.
Gotcha. I think it has to be from that space.
Yes. And as he stated before, he did say that it was occupied as 4 units previously in 2009.
Mm-hmm.
So we do know that it is capable of handling that amount of dwelling units.
Any questions?
No.
All right, thank you.
Thank you.
Call calling 2018-201, 4434 Falls Road, Patrick Richardson. All right, Mr. Richardson?
Yes.
We have this as an application to use the premises for gasoline station with accessory sale of convenience items and attached mechanical car wash, remove repair bays and remodel interior as convenience store, construct new side car wash addition, retain existing pump facilities. Is that correct?
Yes, Your Honor.
All right. If all those intending to give testimony would raise their right hands to be sworn, please.
Swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
And do we have staff reports?
Yes, thank you. Planning Department has reviewed this application. The basic issue that the department had was with some details on the site plan that was presented by the applicant. The applicant is working with Planning Department staff to resolve those minor issues that relate to specifically a handicap parking space and the adequate provisions for an area for that space. Part of that is in relation to the proposed use of the car wash, which requires that there be stacking spaces for vehicles awaiting washing. The department therefore recommends approval of the application be subject to the condition that all improvements are completed in accordance with the site plan that is finally approved by the Planning Department. Thank you.
Thank you, Mr. French. Mr. Richardson, are those conditions, or is that condition stated by the Planning Department acceptable to your client?
Yes. I mean, this is the owner, Mr. Davender Chibb. I'll let him say yes.
Yes, I'll go with the chip.
Okay.
Davender,
Sing chip, yes.
Davender, D-A,
D-A-V-I-N-D-E-R.
D or D?
D like a David.
Sing,
Sing is my middle name. S-I-N-G-H.
and last name is?
Last name is Chibb, C-H-I-B.
Okay. All right, and Mr. Richardson, why don't you walk us through what's being proposed here?
So Mr. Chibb currently has 4 service bays in the building and a very small convenience store towards the back rear, closest to the pumps in the building that's there now. There's no change to the building to convert the the service bays to a convenience store. He's have struggled a lot with getting people in to get service done on their cars, and he feels that the convenience store is going to be a better use for the property than it is. And then also he would like to be able to put a car wash that would be built on the south side of the building. The access would be around the rear of the building, and we would provide sufficient stacking. And so we'll have to comply with the Planning Department's request about the handicap parking space, but we have ideas how we can address that issue and get their formal approval for the plan. So that's what Mr. Chibb intends to do.
Okay.
So the existing pumps stay?
They will stay.
They'll stay.
How many cars will you be able to stack here?
I believe in the final plan I did, I have 10 of them.
This is located on the...
9 of them, I'm sorry.
This
This is the southwest corner of Cold Spring and Falls Road.
Okay.
The Exxon station there.
Mm-hmm. I was just trying to orient myself mentally with the intersection.
Yes. There's a gas station on the northeast side, the Poly Western Schools on the northwest side, and the southeast side is some retail stores and offices, right?
Yeah.
And immediately to the south of Mr. Chibb's is the Carroll Independent Fuel gas station.
So your drawing shows 3 cars, but that's not, I mean, I
There's
see
room for, there's room to,
lane, yeah.
yeah, there's room for 9 to.
9 total.
9 total.
Okay.
And I guess it's envisioned that traffic would go out onto, I guess, Falls as it exits the car wash facility?
Uh,
Go either way.
Yeah.
Falls and, it can go either Falls way, Falls Road or Old Spring Lane.
The front of the site is pretty much open.
Yeah. I see that, it's right there on the intersection, and I know that there's access points from either. Just looking at the flow, in order to get, if a vehicle was on, I guess had gone through the wash, to get onto Cold Spring, it'd have to drive through the pump area. The most immediate exit would be Falls.
The most convenient way to get in and out of the station is on Falls, particularly to get out onto Falls, because to go onto Cold Spring, you have the divider there, so you have to go east on Cold Spring. Now, you can get into the left turn lane if there's a lot of traffic coming, but it's
rare.
easier to get onto Falls Road. I've been there a few times. It's just easier.
Yeah. All right. Okay. Any questions? All right. Thank you all.
Thank you very much.
Thank you.
I'm calling 2018-203, 1958 Hollands Ferry Road, Taisha Ruffin.
Hello.
Hello. Okay, and Ms. Ruffin, we have this as an application to use the first floor as a grocery store / deli. Is that correct?
Yes, sir.
All right. Ma'am, if you would please raise your right hand to be sworn.
Please swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right. Do we have staff reports?
Planning Department has no comment on this application. Thank you.
Thank you. Okay, and Ms. Ruffin, why don't you tell us about what you're proposing here?
When I purchased the property, well, I'm proposing to turn it into a deli / grocery store. If granted the conditional use of the property, it'll serve beneficial to the community where there are very few grocery stores in the area right there. I will have access to fruits and vegetables daily, as well as full meals that can be prepared at home for the families in the area, such as infant formula, milk. When I purchased the building, it had already been transformed and configured as a community establishment. Structurally, it has a brick storefront, cooking and refrigeration equipment already there. It has been converted over with like a cashier and waiting area. I understand that the area is industrial right now. However, this particular division of that area is set up identically as the property that I'm proposing to use on Pratt Street and many other commercial establishments in the area, being grocery stores and delis, which have been recommended by the Baltimore City Planning Office and also approved by the Zoning Board. I believe that it'll be beneficial for the community in the area to have access to the items that I am preparing to sell. Also, I do have supporting pictures and
Sure, if you've got
any information. Yes.
anything you want to hand up.
It's electronically, is it possible for me to?
Well, I'll say that we do have a number of aerial photographs of the property. We got a Google Maps picture of the front and side, and then we have 2 aerial pictures from December 2017. We also have a drawing depicting the interior layout. So we don't really have the ability to take electronic pictures,
Though if there were any images that you wanted to send in after, we can certainly receive those and
Okay.
place those into the file.
Yes, I'll submit those. I have interior pictures.
Okay.
All right, thank you.
This drawing that you supplied, where is the grocery area?
The grocery area would be basically the front 2 rooms. I would prepare, like, most of the meats that'll be deli meats would be prepared for them and hand it over to the customer.
So it's not a grocery store, it's a...
No, it's more of a deli, and just serving like fresh fruits, vegetables. They would ask for what they want, and then it would be, handed to them. So they wouldn't be walking around doing any shopping by themselves.
Gotcha.
It would just be more for convenience, items that you may need but don't, have access to at the moment. And it's not any larger grocery stores in the area right there, so.
All right, and when we see that you've got the front waiting area, a food preparation area, and then food storage, then you've got, looks to be the largest room is all the way in the back. What would be in there?
It would be storage as well.
Okay.
One question, in that back room depicted a restroom. Would that be a public restroom?
No, it's not a public restroom. It's only there for employees. And it's closed off so that it's not facing where any food would be stored.
Okay. Any other questions?
It's not a storage.
All right, thank you very much.
All right, thank you.
Is this the one that?
And then I guess we got your next one, we'll call that now too. It's matter number 2018-204, 2558 West Pratt Street, also Tisha Ruffin. Okay, ma'am, since Ms. Ruffin was already here and she has been sworn, if you would please raise your right hand to be sworn. Thank you.
You swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, nothing but the truth?
Yes, sir.
Do we have staff reports?
Yes, thank you. Planning Department has reviewed this application, noted that this particular property is near to one of the Inspire schools, or 21st century schools, being renovated under the Inspire plan, the Frederick Elementary School, and that it happens to be about a block and a half away from that particular building, and is therefore in an area where there is a lot of student foot traffic to and from the school during school year. The department heard some concerns from the community about reopening a retail goods establishment on this major walking route known as Franklintown Road, which is very near this property. Could contribute to problems in the community. And the department recommends that approval of the application be subject to conditions responsive to community concerns about loitering at a nearby similar store in the community and the safety of students attending the nearby public school. Thank you.
Thank you. Okay, Ms. Ruffin, why don't you talk to us about the proposed use at this location?
So I'm proposing the same use as the prior property. It's going to be grocery stores / deli, just serving needs in the community, fresh fruits, fresh vegetables, milk, formula, so forth. I am prepared to make any necessary accommodations to the community. My property that I'm proposing use at it's a little more than a block and a half. There's Westside Shopping Center, which is actually almost directly next to the school. I would assume would probably be a little bit more concerning. I will be prepared to hire any type of security or any staff required to make sure that there's no loitering in the area, as well as the property has recently been added with surveillance everywhere. There was an issue with dumping in the backyard because it's a corner property, and trucks would pull in the back and they would dump all of their trash in the yard. I have moved the trash out of the yard. My cousin owns the property various times before me, deciding to lease the property from her. So we have been making changes to kind of stop that in reference to your concern. that I'm aware your property faces the back of my property.
Back of my property.
Okay. Yeah, so I definitely apologize, but since the cameras have been added, there has not been any dumping. And more surveillance and security measures will be taken.
Like what?
If I have to hire security in the area, or make sure that the time of the store does not, open when the kids are going back and forth to school, if that's going to be their travel passage.
Mr. Baumgarten, do we have any other permit information on this property? I see we've got, I guess, records going back to 97, but
Prior to 97, we could not pull anything. 97 was approved for use as a first floor confectionery and carryout. In 2000, near 2000, it was approved for use as a barbershop. And in 2006, it was approved for use, first floor for use as a grocery store. We don't have anything prior to 1997.
okay. All right. Yes, ma'am.
I'm sorry, this property as well is already converted over as commercial. It's a storefront, and it has everything. It's set up completely interiorly as a grocery store already.
Okay. Is that it before we turn to your opposition?
I'm sorry?
Is that it before we turn to your opposition?
Yes, sir.
Okay, ma'am.
Sir, I don't mean to
If you
be-
could state your name for the record.
Oh,
ma'am.
Francis Tates. I don't mean
And
to
that
be.
microphone turns if you need to bend.
Okay. I don't mean to be disrespectful or anything, but I lived around the corner from there since 1976. None of those things that he says were there were there.
Okay, why
What
don't you tell
was
us
there?
what was there?
Well, before I came, they said a lady had a beauty shop. That's what they told me, but I text my daughter when I was here. She's 49, and we were 7 when she don't remember any stores ever being there. And the people in the block are afraid to come here. I don't know if you're familiar with Mr. Kyle Legs. He's head of the planning department for that whole area for the city of Baltimore. He was the one that contacted me and told me to show up. And also, Pastor Charles Mullins at the church contacted me and asked me to show up. Because the sign that says they're trying to turn this into a store is in the alley, on the alley wall, not in the front of the building. And that block is already filled with drug dealers, sellers. So police are at the top of that hill a lot. So why would anybody want to put a store in a deli where all this drug traffic is? And the pastor asked me to come because he works, because he has a small congregation, and he couldn't afford to take off. And Mr. Legs asked me to show. The people are afraid to come because the last time I put up a complaint about a business in the area, I got like $4,000 and some dollars worth of damage done to my car by a hit-and-run person during the day, and nobody knew who did it. And the man that owned the company, some people came from out of their store, it's a meat packing company, and was laughing and say they hit them, out of your car. So they're afraid. I ain't afraid of nobody but Jesus. So, I parked my car around there. They put scratch marks and everything on it. So now I guess, I don't know what they're going to do. But that place is not for it's never been any of those things. And I could get, I don't know how many signatures. And I also was told, I don't know if it's correct because I don't know where to check, that once a place has not been a business for a certain amount of years, you can't go back and call it a business. And those are all residential houses, and the majority of those people are homeowners, and the rest of them, the ones that's not homeowners, live in people that own the houses and took the Section 8 because they're getting $1,200 a month to live where I live.
Okay. So it's probably useful to sort of go through, I guess, the legal issues that are here. So the application is for permission to use the premises as a retail goods establishment under a provision in the zoning code relating to neighborhood commercial establishments, which is a new classification of structures under the zoning code, which was passed the end of 2016. 16. And if we find that the property is one which qualifies as a neighborhood commercial establishment, there are a number of different uses which are permitted under that classification. Now, so while it formerly had been the case that if you had a commercial use in a residential district, where you had, that commercial use was non-conforming, and so long as you continued it, it could continue, but where you discontinued it for some period of time, yes, under that situation, you lost the ability to bring that commercial use back. The neighborhood commercial establishment designation really was addressed to that situation, and no longer is it an obstacle to point to some period of discontinuation of use. It's a bit of a different consideration. Now, one of the things that we need to find under the code is that the building was originally constructed and used for a commercial purpose. And while there are some kind of hallmark signatures of these commercial structures in residential districts, they tend to have a doorway that's built on an angle. They tend to have a large display window in the front, among some other things. I note that there's an absence of that with this property. It's just normal doors on the front, and there's not a large display window.
No, it is.
It's a large window, sir.
I know that there is a window, and I think that you would like us to conclude that this is not a neighborhood commercial establishment.
No,
therefore
I was just making sure that.
We do have photographs of the building, so I know.
Making sure you know that.
Yes, I know exactly what it looks like. Yes. But a display window is much larger than that. This is just kind of a large front window. A display window is like where you've got the entire, yes, we have the storefront window where it's floor to ceiling with a large window typically to display merchandise and things like that. So I note that there is an absence of that in this depiction. That said, though, I do note that there is, it's a corner property. There is a projection on the front out from the first floor front of the property, which looks like something had been affixed there. It may have formerly been a larger display window, but that also is something that's which can be indicative of prior commercial use. Since you've lived there for, I guess, so long, what uses do you recall being made of this property?
None. That's what I'm saying.
So what you're saying is it sat vacant for the last 40+ years?
No, I don't think anybody's lived in there in a long while. When did you purchase the property?
But not talking about living in it.
No.
I'm saying, but what use was made of the property? Well, when you say none, that means that it's been vacant.
Nobody is there now.
It may not have been anyone living there, ma'am. But if it functioned, just a minute. Slow down.
Okay.
Was anyone making regular use, whether they were living there, operating it as some kind of commercial establishment, a barber shop, hair salon, candy store, anything? Was anyone making regular use of the property?
Not to my knowledge.
Okay, all right. So what use was being made of the property?
I couldn't tell you, sir. I guess it's like a lot of other buildings. People buy them and write them off at the end of the year for tax laws, it's for rent or something.
But you were there. I'm trying to say, did it sit vacant?
Yes.
Okay. Was it boarded up?
No.
Okay, so it wasn't boarded up, because typically vacant properties are boarded up because you get vagrants and whatnot moving in and out otherwise.
Most of the houses in that block are in pretty good shape.
Okay, so it sounds like you don't think it was vacant, but you can't recall
what
Now,
use was
I know
made.
it was no businesses there like he said, but I don't know if it was vacant or not, but most of the time, there's no one in there. I park my car on that street. That's another reason why I'm complaining, because on the one side of the street, the drug people are out there 24/7. That's the only side that I can park on and feel comfortable if I choose to go in my back to take my groceries in, because I can't hardly park in the front because
Can you
it's
use
a
the
big.
microphone
Oh, I'm sorry, sir. Because it's a business establishment in the front, and you can't never park your car there to get your groceries out the car. So, but like I'm saying, this is where she's talking about, and across the street right there is where all the people sell all the drugs, where all the people sell all the drugs. So I don't understand why anybody would want to put a business there, but then that's another question.
Well, it's not really a question, because
'Cause
people can do whatever they want to
Right,
do.
but the police, it's got so bad around, sir, 4 people got shot in 3 blocks in 1 month.
So?
And they put the police on the corner of Pratt and Franklin Town. And this is like 5 car lengths from where she wants to put a deli and a grocery.
Okay, but that doesn't mean that someone, if they so choose, it doesn't mean that they can't put a business there if they want to
I
operate.
didn't say they couldn't, I said I didn't know why they would want to.
I know, but my point was that's really irrelevant to our consideration.
Okay.
It's more
But how
trying
can
to
you,
find out
how can you
information.
base your
Hold on.
decision on things that he said that just aren't true?
Well,
Where did that
but-
information come from?
But ma'am, it comes from the city's legal record of
Mm-hmm.
uses. So people came to the city and
Mm-hmm.
they filed permits
Mm-hmm.
for uses, and legally established those uses. So that is why there's actually a physical legal record of these things.
But did they ever do that?
That doesn't matter. That does not matter. What
Okay.
matters is there a record of legal use and establishment as an establishment of those retail uses? But the bigger question, really, as I
But
said.
Mr. Washington, chairperson, may I ask what I'm trying to say?
Just a minute, ma'am, just a minute.
Okay.
The threshold inquiry that we need to conduct here is, what was the original use of the property? Was it residential or was it commercial? If it was originally used as a commercial structure, it doesn't matter what use subsequently was made of it, because by right they would be able to ask for that now. If it was not commercial, so let's say that when the building was originally built, it was built as a row house. Okay? And then let's say some years later, somebody says, well, you know what? I don't want to use this anymore as a dwelling. I'm going to operate a store out of the front. Okay? And then, since then, maybe since 97, it's been used as a commercial property. If that was the case, then it would not qualify as a neighborhood commercial establishment, and therefore what's being sought wouldn't be permissible. So that's why I'm really trying to be more focused on that, sort of what is the historic record or evidence of that original use of the property.
But that's what I'm trying to ask you, sir. If it was all these businesses there, does it necessarily mean because the people applied for a license to open a barber shop or a store, did they ever open it?
That doesn't matter.
Oh, okay.
Okay. But as I understand your testimony, you lived there for,
Since 1976.
okay, and you can't specifically recall any commercial use being made of the property in that time?
No, sir.
Okay. All right. Anything further, ma'am?
No, I have one question. If you have to make your decision today, because I could get a list of people have been around there longer than me, to sign it, but they didn't want to come here because they're afraid of retaliation. I'm not afraid.
Okay.
Would it
But
help?
no, we're going to decide it today. So if anyone's
Oh.
not here, we're not really going to have the benefit of anything that they're going to do. Okay. All right.
All right.
Ma'am?
Yes. I apologize for what you've been through, and I understand that there are other people in the community that may not sell drugs or use drugs, such as yourself, that is still in the community and has been there for a while. And your house is on the opposite side. So you're parking your car about a city block long and a half to take a shortcut through your home because there's another commercial establishment on your block?
I don't go through the back way all the time.
Okay.
But I'm saying if I chose to, but like my life is almost over. I'm almost 70. So I had bladder cancer, so I ain't got long. I'm just trying to get a little peace before I go.
If there's anything that I can do, if approved, to make it.
Well, you let the people around the corner know when the drug sales increase, instead of me ignoring them, that I will be calling. And I have a hotline number.
I suggest that you do that.
That's what I'm gonna do.
That's what should be done when they're selling drugs. But again, like I said, I've put up surveillance and I'm trying to do all that I can do. There are a ton of businesses in the area. Westside Shopping Center is about 2 blocks over.
With plenty fast food.
There are people in the area that have children and that need items. And I apologize for any of the drugs in Baltimore City. But what I was trying to do is just provide for the community, the people that need it, whether they're on drugs and need food or selling drugs and need food. I don't intend to use my operations for anything dealing with drugs or loitering, and I will take those measures. I have children myself. I don't want them, in and out or around me. I have 20-year-old, I have children in college. When they come home from North Carolina during the summer, they'll be there. They'll be helping me. And I wouldn't have them in an unsafe environment.
And Mr. French, does the department have any information as to the original or any of the historic use of the property other than what's in the permitting record at this point?
No, unfortunately, we didn't prepare anything like that. Sorry.
All right. Thank you both.
Thank you. I'm sorry, can I say one more thing?
Sure.
My
Ma'am,
insurance
you can
company
come back.
pulled up some
Ma'am?
other uses. BG&E, there has been activity in the building for the last few years. I can send you BG&E records or anything that you need to support that there has been use in there. It has not been boarded up, has not been vacant. It has been occupied, maybe not so in a manner where she has the chance to meet them, considering that she's, around the corner. But I will provide that if you need me to provide it.
Sure, you can, again, if you would like to supplement the record by sending that in, that's fine.
Okay.
Sir, you get a bill from BG&E whether you stay in your house or not. Long as your service is not turned off, you get a bill because they charged me $165 a month for 2 years, and I was staying with my daughter. That does not say that someone was in the house. Just
Yeah.
like your water bill comes whether you're in there or not.
Ma'am, the understanding isn't that that information is, that information would be determinative, just simply that if the applicant would like to submit that, we can receive it into the record. Okay. You want to call this last one?
Yeah, might as well do that.
All right.
Calling the case, 501 South Monroe Street, Appeal 2018-209, Kuljit Singh. Good afternoon. Let me get you sworn in.
Yes, sir.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Sir, your name is Kuljit Singh?
Yes, sir.
Okay. And at any time, sir, have you been represented by the law firm of Adelberg, Guido, Dorfin, Hendler, or Kirk Kolodner?
No, sir.
No? Okay, all right. I needed to find that out because your name was, I guess it's similar to a name of a client or a firm. Had you been the individual I was thinking of, I would have had to recuse myself from this case. But as you are not that individual, I guess I do not have to recuse myself. But you were continuing, so I'll let you continue, Mr. Bonovich.
All right, Mr. Let me get you sworn in.
I already
I
did.
think you did.
Okay, good, good. All right, why don't you, excuse me, why don't you tell us what you want to do?
So currently we're running 80-plus cabs in Baltimore City. And due to the industry changes, Ubers and Lyfts, our revenues have dwindled, and we cannot afford to outsource body repairs for our vehicles. So we're trying to get that done in-house. And currently, we have about 80 families that are being supported by this business, whose only source of income are these cabs that we run. And also, only items that we're not looking to become a full-blown body repair shop. All we're asking for is minor repairs where we're able to replace bumper covers, fenders for our vehicles, because sometimes the vehicles are placed out of service if the bumper cover is damaged or fenders damaged. And if we have to outsource this, sometimes the vehicle is parked for days and weeks at a time.
Okay.
And the drivers, they cannot afford to lose that time.
Okay.
And all we ask for is the minor repairs. We're not asking for the major. Our property won't allow us to become a body repair shop.
Well, let me hold you there. I forgot to ask if there's any staff reports. Mr. French?
Yes, thank you. Planning Department has reviewed this application, and as Mr. Singh is alluding to, the question will turn on whether body and fender repairs as proposed constitute motor vehicle service and repair minor or motor vehicle service and repair major. The Planning Department believes that the proposal is in fact to be characterized as motor vehicle service and repair major, which is something which is not allowed in this particular district, which is a C2 zoning district. The department is recommending disapproval of the application because the proposed body and fender repair shop would provide collision damage repair services that are only allowed under the category of motor vehicle service and repair major, which is a prohibited use in the C2 zoning district, and the approval would therefore constitute creation of a new non-conforming use, which the board is not authorized to approve. Thank you.
Okay.
Mr. Chair, I would add, at the time the appeal was filed, it was characterized, or there was testimony that engine repair was going to be part of this appeal. So per the code, that would constitute major versus minor. So if that's not the case now, the appellant should clarify.
So why don't you clarify? Tell us what you put on the application. If that's different now, let us know what's different. And then I really want to understand the collision service, exactly what you're going to do to these cars.
Major collisions we cannot perform at the shops. They require large equipment, and our property is small. There's no way to fit those equipments on our property. All we want to do is the fenders, bumper covers, they'll come pre-painted from different shops that are approved by the company that we subcontract with. So we'll have the parts there, such as bumper covers, fenders, painted already. All we're looking to do is replace them. And for engine repairs, I think we're already allowed to do minor repairs on engines, such as tune-ups and oil changes, and that's all we require on these cars.
Okay. So there will be no painting, there's no spray
painting.
booth in your
No,
shop?
there is no booth, no.
Okay. It's a little unclear reading the code. The code talks about collision services including body frame and/or fender repair and/or straightening or painting. That's the major repairs. The minor repairs doesn't talk about any sort of body repairs. So we're going to have to think about whether this replacement of the bumpers and bumper covers equals a major or minor.
Okay, and another item, some of these vehicles right now, if you have to change a headlight bulb, it requires you take the bumper cover off and then replace the bulb. So I hope that's in the same category as the minor.
Okay.
Okay.
Okay. Anything else you'd like to add?
That's all.
Okay. Any questions from the board? No. Thank you.
I have just one. The kind of work that you're planning on doing, would it be kind of more along the kind of work that you might have done at like a Pep Boys, Jiffy Lube, that kind of a place? Or are you looking at more more significant repairs than that?
We don't work like Jiffy Lubes or Pep Boys. We mainly work on our own fleet vehicles. About 90% of the work that's done at my location is.
Well, not that you would have customers come and do that, but I'm saying the type of work that's done. So wheel rebalancing, replacing tires,
Yes.
Alignments, replacing fuses, light bulbs, working on if there are, some hoses from the HVAC system or any other systems,
Yes.
Changing those out. So is it more that general kind of work?
Yes, currently we're doing that type of work, replacing tires, brakes, rotors, safety inspection of the vehicles, AC work. We also do that, radiator replacements, we do that, air filters and tune-ups of the vehicles. We take care of those
Now, you
items.
said that you're doing that currently, so
Yes.
what would change?
All we are looking to add to our licenses, the body parts replacement. We were told that we're not allowed to even change the bumper covers of the vehicles. And most of our cabs, if bumper covers, fenders, they're constantly damaged. And in order to get them fixed, we have to send it to other shops. And when we send them, it takes days to get them fixed. And where at my shop, we can do it within about half hour because we have parts ready to be placed on the vehicle. The paint is done by approved shops by our contractor, which is Transdev. They have only certain shops that we can get our vehicles painted at. So we get those parts painted at these locations and we'll have them at our repair shop. And all we'll be doing is replacing those parts.
Okay, so you'll be replacing, I guess, the damaged body parts
Yes.
on the vehicle. So doors, fenders, et cetera.
Yes.
All right. And everything else, sort of the more, like the Pep Boys, Jiffy Lube type work that you're doing now, that'll continue. The only thing that'll change is you're looking to do this body type work.
Yes, just to, it's a minor repairs.
Basically, it's taking the part off, putting it on, that kind of
That's
thing.
it, yes. And,
With everything pre-painted,
yes, yes.
painted outside of your shop?
Outside of shop, yes. We subcontract with Transdev. We're the largest subcontractor of Transdev, the checker cab of Baltimore City, and they only allow certain shops to paint the vehicles so it would match, the colors would match.
Okay.
Okay. Thank you.
So your
Thank you.
auto sales,
We
what
also,
is it- that's a part of what's
yes.
currently going on?
We have auto sales and tag and title at the location. The auto sales mainly accommodate our fleet. We buy vehicles and sell it to our own fleet. And there's barely any sales being done to outside public.
Okay. So you're not buying cars at auction and repairing them and selling them?
Very few, very few. Mainly we buy for our own fleet.
Okay.
But you are a retail auto dealer?
Yes.
Okay. Okay. All right, thank you.
Thank you. Thank you very much.
Okay. All right, and 2018-150, 1823 Lancaster Street, unit number 28, Herbert Burgunder. Okay, Mr. Burgunder, we have this, afternoon, sir. We have this as an application to retain newly constructed deck built pursuant to permit number COM 2017-14095. Is that correct?
That is correct.
All right. If all those intending to give testimony would please raise their right hands to be sworn.
swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
And do we have staff reports?
Yes. In the file, we have 3 letters of distinct opposition, but we also have a couple letters of support and a petition that is signed by 9 individuals that are in support of the appeal.
And the planning department has no comment on this application. Thank you.
Thank you. All right, Mr. Burgunder, the floor is yours.
If I could start with by way of just a bit of an introduction, in that this is a bit of an unusual case in 2 respects. One respect is that my client lives in a condominium building that the front door of which faces a park, which faces Wolf Street. The address on SDAT is on Lancaster Street. His and his wife's mailing address is on Thames, and the entry is on Thames. So we have 3 different properties, 3 different streets, all affiliated with this property. That's the one unusual aspect of it. Coupled with that is that my client lives in a condominium, and the condominium unit itself is limited to the box in which they live, and the deck at issue is in the common element of the condominium association. That's one unusual aspect of it. The second unusual aspect of it is that my clients went over the period of August of 2017 through March of 2017 and sought and submitted an approval, a permit request to Baltimore City, and that was processed through the whole process. It went through the Neighborhood Association, the Design Review Committee approved it, CHAP approved it, all the departments of Baltimore City approved it. They went and got a lease so they could lease the place where the footers would go, because again, it's not their property, it's the condominium common area. And they constructed the deck attached to their unit. It replaced a deck that was smaller in size and extended it. And it extended it to the same length as their immediate neighbor, who got approval from Baltimore City under permit to do so in 2006. And so those are 2 unusual aspects of it. There came opposition during the period of construction, which was well after the permit approval in November. The delay in constructing was due to the fact that Ms. Mandel had a baby at the time that the construction could have started, and obviously Mr. Goldberg and Ms. Mandel had some other things on their mind, so they didn't start construction right away. But to accommodate the interests of the neighbors, and at the suggestion of Mr. Veal, we did file for a request to retain the built deck that we built under the permit approved by Baltimore City and inspected by all the inspections. So that would be the 2 unusual aspects of this case.
So can I assume that given, well, yes, you said that your clients obtained a lease from the condominium association for the location of the footers?
Yes.
Okay. So can I assume that the condominium association and the council of unit owners approved the construction of the deck?
Yes.
Okay. And what significance do you attach, if any, to the addressing of the property, that is, it's addressed on Lancaster Street?
I don't know that there's any significance to it, except for the fact that the front door of and we can have pictures and I can have testimony from my client, but the front door of their unit faces the park, which faces Wolf Street, and we have photographs that we can provide and testimony to that effect. The address, and I'm not sure why, is on Lancaster Street, but the Motor Vehicle Administration and the Postal Service require my clients to have on their driver's license and for their mail that their mail goes to Thames Street.
Well, and I guess what I'm getting at is that what we have here is part of the variance that's being sought is a rear yard variance, which if the property is addressed on Lancaster Street, because as I understand it, this is a condominiums, you said?
Correct.
And so it's sort of one large building in effect. There's no subdivision or no individual lot lines separating each unit.
Correct.
And with the property being on Lancaster Street or being addressed on Lancaster Street, then are we dealing with a rear lot line variance? Isn't it more interior side yard?
Actually, given and this is more a legal argument, I'd be happy to have my clients testify as to some of the facts and show photographs, because I think actually that would elucidate the bit of an unusual and unique situation that exists here, having 3 different addresses. The zoning code obviously speaks of where the address is. We actually have 2 different addresses, neither of which is the front door. So the Postal Service and the Motor Vehicle Administration, and consider the postman or postwoman, when bringing mail, would not deliver to Lancaster Street, although SDAT calls it that's the front. They would, the Postal Service delivers, and the MVA considers the address to be on Thames. But if anybody looks at it and you see the front door of the place, the front door faces a park, which is on Wolf Street. So the this is the view of the front doors, and you can see in a more, and I can have my client testify to this, this is their front door, how they enter their home, and that's through a park that is here on Thames Street. So you see the park, everybody knows, if you've been down to the area, you certainly know where this park is, and the building is here with the condominiums in them. This is the park. This is Wolf Street. This is Thames, and this is where the entrance is to their, where they park underneath the building in the common elements. And then Lancaster Street is up here on the northern side of the drawing. So I don't think actually, there is no rear yard. There's no yard. It's the condominium common area in which there is an existing projection into the yard of the deck. And that projection was increased to match the, sure.
I guess where I was going is that looking at 1309 provides a lot of different definitions for lot line. And 1309C defines lot line front. Lot line front means the lot line that coincides with the right-of-way line of an existing or dedicated public street from which the property derives its address. And that's important because lot line rear means the lot line that is most distant from and opposite from the front lot line. So if the property derives its address from Lancaster Street, that's the legal description of it. Post office is one thing, whatever.
Well,
the legal description is Lancaster Street. So the property is on Lancaster Street. Then, okay, that's the front lot line, and the rear lot line would be on, I guess, Thames. Now, of course, all of this, you're looking at me very perplexed, and I'm very familiar with the orientation of this property. Sure. Yes, the front door of the property actually looks at, or the front door of your client's residence looks out on a park.
That is true.
It's nowhere near Lancaster Street. That doesn't change the fact that the legal description is on Lancaster Street, so under the code, then that makes Lancaster Street the front lot line, Thames Street the rear lot line. And now we're talking about what would be the interior, or what would ordinarily be the interior side lot line. However, lot line interior side means lot line that does not adjoin a street and is not a rear lot line. But that, since we're not dealing with subdivided properties, isn't that just the boundary line of the overall condominium? Which I think all these are the questions that Mr. Veal was getting at when you were trying to determine, all right, well, is there a variance that's needed? What kind of variance is needed? Is there a variance needed at all, et cetera? And all that is dependent upon what you define as the front lot line, the rear lot line, the side lot line. Because if the lot lines are basically Lancaster Street, Thames Street, whatever that is in the back, and what we're really dealing, and there's no interior subdivision, are we even at a point where a variance is necessary, given that we're dealing with basically construction all within one large piece of property?
Correct. I don't believe that a variance is needed because it is construction within one property. The situation is so unusual that it seems to me that the relevant issue is, do we have approval from the condominium association to do so? We do. And did it go through the process with Baltimore City, including the process with CHAP? We do, and it did. I don't believe that a variance is needed. I believe that the structure was built in accordance with the requirements of Baltimore City, in accordance with the permitting process, that we have all of the evidence and the documents to support that. We're happy to introduce those into evidence, and if I could do that through my clients, but I don't believe that a variance is needed.
Okay. Did you receive council's letter of June 19th?
Yes.
Okay. And what is your response to the positions articulated there?
So the letter itself, we obviously would object to it for the record, object to the entry of the letter into evidence in that it's hearsay, but it's also hearsay based on a misunderstanding or an incorrect fact. So the issue and some of the issues and the analysis that was done by Mr. Leon and by others in the emails and in the letters, and in fact in the letter itself by Mr. Schuster, was based on an understanding that the neighbor had not received approval for their deck. So there's an immediate next door neighbor. This is actually on the Lancaster side of the property. This is a deck that was constructed by the neighbor in 2006 with a permit from Baltimore City. So it's a little hard to see because of the angle, but it's this, you can actually see it here. This is the deck that is on Lancaster Street. Not standing in front of the microphone, but this is the deck that's on Lancaster Street that goes all the way out and touches Spillman's building. And that was constructed.
That's the deck you've been referencing.
That is the neighbor's deck that was built in 2006. And there was some misunderstanding, and I'll explain why there was a misunderstanding as to the permit approval from 2006. And if I could enter into evidence, and I have a copy of actually, if I could right now, Mr. Washington, I have copies of all of the exhibits I'd like to present to the board.
Thank you.
So in that packet is the, and this is actually goes to the confusion as well, and why the city was not able to find the permit, although we did share it with them when I found out that they didn't have it. So the owner next door is Robert Bauman, and this is toward the end of the packet. There's an SDAT printout for the neighbor's address. This is the third from the back, although my packet has gotten.
Okay, I think I found it. Yes.
So Mr. Bauman, or the predecessor in interest, you'll see, actually, it says his mailing address is 1832 Thames. The premises address is 1821 Lancaster Street. And the legal description is 1,730.8 square feet, unit 29, same as 1832 Thames. So the neighbor's address is a little bit confusing as well, and you could see why the city wasn't able to find it. So the premise of the memo is based on a misrepresentation, not intentional, unintentional, I believe, misrepresentation of what actually happened. And so the second page of that is the printout from Baltimore Housing from 2006. You'll see a permit, COM 2006-2
27903, remove deck and replace same size and location, 14 by 9. This was from 2006. And then you'll see the permit, the actual permit itself that was issued, and the application on which that permit was based, including the printout show that the fee was paid and the drawings on which that was based. So the basis of Mr. Leon's comments in his email, and which I believe were outside of the purview of CHAP, but be that as it may, and the basis of the comments as it relates to, in the letter from Mr. Schuster, as it relates to the fact that the neighbor didn't have approval, the neighbor did have approval. So it just, again, it all points back to the fact that this is a bit of an unusual property with multiple addresses, and I believe that was the mistake that the city made when they went to look it up. They weren't able to find the permit and thus concluded there was no permit, but there was. With regard to, I'm not sure if there were other issues that were raised in the letter, but I'd like to, if I could, have my clients briefly testify. I know it's late. Mr. Goldberg. If you could state your name.
Sure. Elon Goldberg.
Okay, and with you is your wife, Sarah Mandel?
Yes. Yes.
I-L-A-N.
Goldberg with an E.
Yes, sir.
Sarah with an H or no?
With an H.
And Mr. Goldberg, when did you purchase the property at 1823 Lancaster, also described as on Thames Street?
Sure. It was on or about March of 2013.
Okay. And is it a condominium?
Yes, sir.
And can you describe the contours of your condominium unit?
Sure. So it's a little bit unusual, but the contours.
Meaning, like if you were coming from the street, as former Councilman Cunningham said, with regard to the entrance to the property, is that? Can you describe that and describe the other interior portions of your condominium?
Sure. So when we enter the condominium, we enter through the door, which faces Wolf Street. When we park, we drive through a garage door that faces Thames Street. And we sort of have a drive-through bay, so to speak, where all the cars park.
Okay, I'm going to show you, in addition to the documents that I've handed over, not in addition, in the documents I've handed over, there are photographs. I'd ask that all those documents be entered into evidence in support of this petition. I am showing you a picture that is part of that packet.
Mr. Schuster, any objection?
No, sir.
Okay. Admitted.
Can you describe what you see in that photograph?
Sure. So I'm looking at Lancaster Street from on or about the center portion of the common element back.
Okay, and these are the cars that are parked underneath the condominiums?
That is correct.
And this is another photograph of the same?
So this is a photograph, again, in the common element facing Thames Street.
Okay, and if you could orient the board to the left, in this photograph to the left is which street?
So to the left would be, the closest street would be Wolf Street.
Okay, and to the right is the...
to the right being?
To the right of the photograph where the white car is that the property of the Spillmans?
That is, I believe it is, yes.
Okay. And is in this photograph here, is the deck that you constructed visible?
It is.
Okay. And then, so you enter into your condominium unit, again, if you were walking on the street in the neighborhood and you could come into the park that faces on Wolf Street, and then can you describe the interior of your unit?
Sure. So the interior of the unit, we have a small foyer area right off the park, and then we'd go up a set of steps to our main living area. And again, up a set of steps to the upper third level area. But The foyer areas, you know, I mean, it's a garage, essentially.
Okay. And and do you have access to what are considered common elements of the condominium?
Yeah, well, yes, we do, sure.
Okay, and is that where you park your car?
That's where, yes, we all park our cars.
Okay, and prior to the construction of this deck, you had a deck?
We did.
Okay, and how large was that deck?
The span, it was approximately 19 feet wide by plus or minus 7 to 8 feet in depth.
Okay, and was that constructed when you arrived at when you purchased your condominium unit?
Yes, sir, it existed.
Okay, and is that deck part of the common elements, limited common element in your case?
I believe so, yes. Yes.
Okay, and no one else has access to it. It's attached to your unit, is that correct?
That is correct.
And at the time you purchased your condominium, did the neighbor, Mr. Bauman, at 1832 Thames or 1821 Lancaster Street, Unit 29, did Mr. Bauman have a deck attached to his house?
He did.
Okay, and I'm going to show you what's in the packet of photographs, an exhibit which actually shows the zoning sign. And is that deck that is shown Mr. Bauman's deck?
Yes, sir.
So that's your immediate next-door neighbor?
It's my immediate next-door neighbor's deck.
And if you're familiar, is the house that is to the right with the garage, is that the Spillman's house?
Yes, sir, it is.
Okay. And you sought to replicate that depth of deck at your house?
Correct.
Okay. And to do that, you sought permission from Baltimore City?
We did. So I'm somewhat familiar with the building process.
Okay.
So yes, Baltimore City, the Fells Point Design Review Committee, CHAP, yeah, there was a lot of back and forth. It took us about 4 months to get the building permit.
Okay. And the part of the packet includes a copy of that building permit, is that correct?
Correct. That is our building permit.
Okay. And also as part of that packet, you went through the approval process. There's a document that says Project Docs, which is the printout from the Baltimore City's website with regard to the permit approval process. And is that something with which you're familiar?
That is, sure,
Okay.
absolutely.
And from your experience and from your understanding, this is the list all the different tasks that needed to be done to approve your construction, is that correct?
That is correct.
And you went through all of those successfully, is that correct?
Yeah, we did successfully, but yeah, after 4 months or so, they were completed.
Yes. And did there come a time where you had to seek approval from CHAP, is that correct?
Yes, that's
Okay.
correct.
And you did seek that approval?
We did. We sought it, and we received written permission from CHAP by
Okay.
way of an authorization to proceed.
And it's not in the packet, so I do have actually the original, I'm not sure why, but I know that Mr. Schuster, in his opposition, did have the authorization to proceed, but I do not have an extra copy of it.
That's fine.
So I may submit that. And in addition to, you also submitted to the city, as part of that approval process, the drawings that are reduced in size that are the permit approval set that are attached as part of the exhibit, is that correct?
That is correct.
Okay, and do you have the full-size version of it if anybody has any questions?
I have 2 architectural size renderings, if anyone wants to look at 34
sure
by
if
44
anybody has-
renderings, but
If anybody, the small version we have as part of your packet, we do have the giant version if, I take off my glasses to see the details, but some people put them on. And then in addition to that, did you also receive approval from the Design Review Committee of Fells Point?
yes, sir, we did.
Okay, and there's an email to that effect in the packet? Is that correct?
That is correct.
Okay. And in addition, you sought and received approval from the Condominium Association with a sublease for a portion of the property for the footers?
Correct. That is
Okay.
correct.
And that is part of the packet as well?
Yes, sir.
And there came a time to start the construction of it. I'm going to show you a photograph that's also part of the packet. It's a photograph that's part of the packet. Can you describe what's in this photograph?
So that's a direct view of the Spillman's residence. It looks like we are looking westerly.
Okay. And is the area that you see in front of you, is that where you park your car?
So where we park would be actually where the photo was being taken from.
Okay, someone else parks their car?
Someone, others park there, correct.
Okay, so and that's, again, part of the
It's the common element.
common element. And to the right of the photograph is, I see a circular concrete footer. Is that the footer for Mr. Bauman's
Yes, sir.
deck?
It is, correct.
Okay. And that's in the, as well in the common elements of the condominium?
Yes, sir.
Okay. And I noticed in the picture that there is a projection into the rear yard for the Spillmans. Are you familiar with that?
So what are we referring
Is
here?
there, do they have a balcony or deck as well
It looks like a Juliet balcony.
in their backyard?
In their, I believe it is their backyard, yes.
Okay. And when you were looking, I'll show you this another photograph. This photograph, this is a photograph taken right there. This is a photograph of what?
So again, so that's looking from our old deck, northerly, at Mr. Bauman's deck.
Okay. And is the deck resting on the footers that were in the prior photograph? The circular concrete footers?
This deck is resting on those, yes, correct.
I just want to make sure that there's orientation to see that the
Absolutely,
deck is
yes,
resting.
correct.
Okay. And to your knowledge, this deck has been there and in use since 2006, is that correct?
Yes, sir, correct.
Okay. And, bear with me a second. And is this the deck that you constructed?
It is. That is our deck.
Okay. And is that match up distance-wise with the side of the Spillman's building?
Yeah, on or about. It's
And with the deck that was previously there from 2006?
correct, yes.
Okay.
Same plane.
Okay. With the board's indulgence. And I'm not sure if that Mr. Veal's letter was part of the record?
We
It
have
is,
that.
okay. Just to make sure that it is part of the record. And did there come a time when you did talk to Mr. Veal about this matter?
Yeah, so we initiated a meeting with Mr. Veal after I had spoken with one of the building inspectors that apparently received some concern.
Okay.
So I initiated a meeting at Mr. Veal's office.
Okay. And I'm going to show you another aerial photograph that is part of the packet, just to give some orientation. This aerial photograph is a little bit more right on top of where the condominium units are. If you could identify for the board the buildings that are at issue. This is the building in which your condominium is located?
That's correct.
Okay, and this is the park that we talked about?
Yes, sir.
And is this the deck that is the Mr. Bauman deck?
That is correct.
Okay, and then your unit is the one right next door?
Correct.
And are there any other improvements in the, that are part of the common elements that also touch and attach to the Spillman's building?
Well, so it looks like there's a masonry wall
Okay.
that abuts.
And is that some sort of privacy screening as well? So
It
the zoning
is-
sign?
It looks like it's a wrought iron fence also abuts the.
Okay, that's a fence. Okay, and is that, do you know if that's attached to the Spillman's house?
I believe it is. I believe it is bolted in.
Okay. Okay, and your object today is obviously to keep the deck that you received approval to build and constructed at great expense, and this would be to, you have a growing family with a young
do.
child, and your intent was to buy this property and to live there as long as you can?
As long as we can, until we ran out of space.
Okay, and this would help to do that?
Immensely.
Okay.
Immensely.
Okay. Now I have no further questions for Mr. Goldberg, if Mr. Schuster does, or if the board does.
Schuster,
Do you want this to be made a part of the record?
Yes, please.
did you have any questions?
I'd like to ask him after I ask my client some questions. that's okay.
Okay.
Ms. Mandel, is there anything else you'd like to add?
No?
No? If you could step closer to the microphone. And you, how old is your child?
6 months.
Okay. And the baby was born during the time of this
Yes.
construction and this process, yes?
Yes, right after we obtained the permit in November, the baby was born, and his name's Remy. He was born in December.
Okay. And the idea is to use the deck for a safe play area that's attached to your house?
Yes, absolutely.
And did you have a chance to, over the years, obviously, being in the house in the prior deck, when you sat on the prior deck, you looked out into the backyard. What do you see? Or what did you see?
We had a clear vantage point of the Spillman's beautiful garden and their Juliet balcony, which they often sit out there.
Okay. And is there anything else you'd like to add?
No, that's it.
Okay. If the board has any questions for Ms. Mandel?
Surface. Sure, thanks.
Any questions for Ms. Mandel?
Not at this time.
All right. Are you done, Mr. Burgundy?
Yes.
Okay. Mr. Schuster.
Okay, thank you. So let's see if we can get some basic information out of the way here. The premise of my letter, and for the record, I want to make sure my letter is part of the record.
It is.
And the accompanying exhibits. And I want those admitted into evidence, too.
And for the record, I'll object to them to the extent that it includes hearsay and to the extent that it includes information that is factually inaccurate.
You certainly can deal with any factual inaccuracies which you want to address. As far as hearsay, it's administrative proceeding, and rules regarding hearsay are lessened, so we certainly will take those for what they are worth, but we'll admit the document.
Thank you.
And while we're at it, for the record, not to belabor the point, but much of what we just heard about who said what and documents that have been submitted in the applicant's case also constitutes technical hearsay, and that's why I didn't object, for the same reasons that the chairperson just outlined. So the property really isn't all that unusual. It's a lot. There's a recorded lot. That's an exhibit to the letter that I submitted on June 19th. The lot shows that the front of the front property line is on Lancaster Street. The rear is on Thames. And how the individual condominium building is subdivided internally is really not relevant. That the people decided to use the front door facing the park, that was their choice, but it doesn't make the lot an unusual lot. Any reference about the post office or the MVA is completely irrelevant. What counts is what's in the land records, and that's how people, when they go to buy and sell property, they look at the land records. That's the only thing that matters. That's the thing that determines the address. Next, the Bauman deck, and I was surprised to hear that it had been approved, because we were told it was never approved. Mr. Veal said it was never approved, and what's been submitted by the application proves that point. So the permit number says permit number 2006-27903 says remove deck and replace same size and location, but they didn't do that. The original deck was what's along that line, and the photographs show it. They actually enlarged the deck, and so, but I don't want to go down that rabbit hole, because what happened next door.
Well, it does provide some measurements there. It says 14 by 19 feet.
Yeah, I noticed that. And on the preceding page, I don't think it, unless I missed it, and I apologize if I did, it just says remove deck. Oh, it does have the measurement, so I stand corrected. But again, what happened at the Bauman property is completely irrelevant to what's happening here. There is no dispute that it's a side yard. The permit was issued the permit in this case that the Goldbergs obtained specifically says it's a side yard. So they applied for it knowing it was a side yard. Under the code, we outlined this in the letter, if it's because it's a side yard and they want to have a deck there, it's just not permitted. So that's really not in dispute. Even if you wanted to call it a porch would not be permitted there either in a side yard. So that's what Mr. Veal that's why he insisted that there be a variance, because
Well, that only applies, because you were talking about it as an interior side yard.
Correct.
And looking at the tax map here, you see that there's, it shows the block and whatnot. And when you look at the definitions for lot line, okay.
Just hold it for 1 second.
So lot line, property line,
Are you in 130?
1309A. Lot line or property line means the line bounding a lot. Lot line corner side. Lot line corner side means the lot line that is not a front lot line and coincides with the right-of-way line of an existing or dedicated public street. And looking at this, the lot line which coincides with an existing or dedicated public street is this one right here.
I gotta get closer, I'm sorry.
Sure. This one right here.
Correct.
Okay. And then we go to table 10-401, which you referenced in your letter.
Yes.
Find corner side yard. All uses in the C1 district. Says for the first 25 feet from the front lot line, where a structure is to be located, must build to corner side lot line. After first 25 feet, no yard requirement. Isn't that what's going on here?
I'm sorry, yeah, I just haven't caught up with you.
Sure,
Where are you in the chart?
All right. Looking at the code, table 401.
Right,
It's on page 446 of the code.
I'm with you.
You look under minimum corner side yard.
Why are you in corner, though? This is not corner.
Because the definition of corner side lot line means the lot line that is not a front lot line and coincides with the right-of-way line of an existing or dedicated public street.
But the line we're talking about doesn't do that.
You just agreed with me that it does. It's right there.
No. I didn't agree.
You don't agree anymore.
I was
All right,
agreeing
do
that
you
your
see,
point- I see-
okay, do you see what I have circled?
Yeah, can I show you this? Because this is a little larger, and I think I could
Sure.
follow
Sure.
along. This is
So long as it's the same thing.
Yes. I think it is. So,
The drawing of the condominium.
Yeah.
complex, which is block.
so the line you're
Sure.
talking about.
Is that heavy line there.
Right.
That's right, okay? So definition of corner side lot line is not a front lot line, and it coincides with the existing or dedicated street. That lot line does.
I don't think it coincides with it. No, this is an interior side lot line. because it doesn't coincide. In other words, if this were a street here, then the line would coincide. That would make it a corner lot line. It would be on the corner of the lot.
Mm-hmm.
This is an interior side because there's no street that it.
And the difficulty here is really where the property is addressed, right? That it's addressed on Lancaster Street.
I mean, that's just reality, yes.
Yes.
That's what the land records recognize it
Yeah.
as, and
Yeah.
that's what it is. Right.
So, and
I don't think that creates a difficulty. That's just. the
well,
rea-
it does in that if the property was addressed on, here we go. I was going to pick up the thought line was I was looking the wrong provision for front lot line. But the difficulty here is with the property being addressed on Lancaster Street. If it was addressed on whatever that, I guess Wolf Street.
Well, there's a park between Wolf and.
That's right. That's
okay.
right. That's right. I
So
said
if-
if it was.
Okay. I
If
mean,
it was, it would make that a lot cleaner. But the point is that whether you look at it as the lot line corner side, or even if you look at it as interior lot line, because that's where the prior variance comes in, the prior permit, rather. Even if you look at it as interior side yard, no interior side yard required. But if one is provided, it must be a minimum of 10 feet.
Right.
So the lot line we covered really applies to not these particular structures that are involved. It applies to the entirety of the property, okay?
Correct.
All right.
I agree with you.
So when they granted that permit back in 2006 or whatever, it got rid of because in order, you look at the definition of yard. Yard, when used with respect to required yards, means the space between a building and the adjoining lot lines that, except as otherwise permitted by this code, is unoccupied, open, and obstructed by any part of the structure from the ground to the sky. So here, once that permit was issued in 2006, the building got rid of that yard because it was now obstructed. It was no longer unobstructed from the ground to the sky. It was obstructed.
It was obstructed, but I don't agree it got rid of the yard.
Well, didn't the definition of sky requires it to be unobstructed from the
Agree with you.
from the ground to the sky? And it is now, once back looking at it in 2006, when they built that, it became no longer unobstructed.
I agree it created an obstruction. I disagree. It eliminated the 10-foot yard.
Well,
I disagree.
here you deal with it like so. There's no, I guess at the beginning there isn't a side yard required. That's the first part.
Actually,
no interior side yard required.
Can I hit the pause button on that? Okay, go ahead. I don't mean to.
I'm just finishing my train of thought
Yep.
here. But if one is provided, it must be a minimum of 10 feet. So it's saying, okay, you don't have a requirement, but if you're going to have one, then it has to be to a minimum of 10 feet. Then you have in 2006, and again, this applies to the entire structure. So, and it's looking at it, if you want to look at it from the perspective of an interior side yard. So it applies to the whole thing, and the question is the building providing for that interior side yard? Well, in 2006, they obstructed it.
with that deck that's there now. So did the building, or did the building from that point forward, did the building provide an unobstructed space from the ground to the sky? And I think the answer to that is they didn't. They obstructed. They obstructed.
I agree with you.
So didn't they get rid of that yard back in 2006? I'm questioning whether we're like arguing this like 12 years too late.
The answer is no, and if I can sort of go back to your analytical progression, I'd like to. Okay, so what you're reading from, I think, is under the new code.
That's correct.
So under the old code, there was a required yard.
Mhm.
Okay, this was a B2 zoned area. It's now C1 under the new code. So, and that is required. That was required. So originally, there was a required yard.
Mhm.
Okay, and then if you go to 15601, whether it's a corner side yard, interior side yard, really doesn't matter, because deck is not permitted in either of those areas. It's only permitted in a rear yard. Okay, so, and
of course, that was the, I guess that was on a going forward basis, because the deck was built 12 years before that provision was enacted.
Right, and I'm sorry, what I'm talking about is the Goldberg's deck. The new deck is subject to 15601. And whether this board finds that it's an interior side yard it's an interior side yard or a front yard, corner side yard, I don't think it matters, because deck is not permitted in either of those yards. So I just want to.
There's a side yard that's provided.
And there is one that's provided. There's no question. I'm not arguing with you that it's currently obstructed, but that doesn't mean that there's not one provided. One is provided. That it's been obstructed doesn't clear the way. And in other words, I think what would be happening here is we'd be turning the law of zoning on its head. If one permit was improvidently granted years ago, that doesn't clear the way for all new permits all new encroachments that would never be permitted under today's code to go forward. Maybe we're stuck, and I'm not so sure I'm ready to give this up. Maybe we're stuck with the 2006 deck. But if this board relies on the 2006 deck as somehow clearing the way and greenlighting every other deck now that's going to go forward, that just turns the principles of zoning on its head. And I don't think this board wants to do that. That's not the direction of the laws.
Would it really? I mean, the way that I read that provision for, I guess, 10401 is it's telling a property owner in a C1 district, you have no required side yard. You don't have to have one.
Today, if you were to if you were to build a structure, that is true. Originally, that was not true. Originally, it was required, but
Sure, originally it was, but we're 18 months, 18 months past
Into it.
enactment of the new code. So the current status quo is you don't have a required interior side yard.
but one is provided, so it must be 10 feet. That's
And then well, the question is, because the building here,
Right.
represented by the Council of Owners, clearly permitted the construction of the deck. They leased out their property for the construction of it. And they're really sort of the one who's in control of what, they're sort of the property owner, if you want to look at it that way, in this instance. The code says, property owner, you have no interior side yard requirement. So there's already an existing deck which obstructs the side yard. The question is there one in existence? And if that space is obstructed at all from ground to sky, then no, there isn't. Looking again at the definition of side yard, because it doesn't say that the entirety of the space is unoccupied, open, obstructed by any part. Actually, it implies that some portion of it is going to be blocked where other portions may not be. But the yard says, is unoccupied, open, and unobstructed by any part of a structure from the ground to the sky. So given that part of the structure does obstruct it, is there an interior side yard that's provided? And if there's not, then the deck could, you can build over that space.
Yeah, I don't think that's the proper analysis because by creating a deck, that doesn't eliminate the yard. So right now, let's play hypothetical, okay? If there were a check mark in one of these boxes, we would say, okay, a deck is permitted in the side yard, but that doesn't mean the side yard disappears from our reality. It just means that the zoning board has permitted it to be obstructed. The side yard still exists, and it's always going to exist unless they put unless they raise the condominium unit and bring a building with no yard whatsoever.
Well, what if it was, because I noticed from the photographs.
Right.
Right? Looks like there's, yeah, here we go, you can see it. So this picture shows that there's this parking that's located under the building here.
Correct.
Right. And what if all they did was they pulled that parking deck out, right? They pulled the wall of the building out over that space, but it was unoccupied underneath, right? It's just an open space that they build the building on top of. So let's say that we're not talking about a deck, but we're talking about a structure. Well, the deck is part of the structure, but nonetheless. But the point is that whether you pull the building wall out over that airspace or you put a deck over it, it's still, the space over it is still occupied. And the question for the threshold issue for the existence of the yard is that the space has to be unoccupied. If the space is occupied, then it's not a yard. And here, it just seems that the space is occupied. I'll grant you the question that if they were talking about, if you didn't have that deck built in 2006, okay, and let's say you had a first-time application these folks didn't build their deck, and you're looking for, is it Mr. Bauman, I think his name is? Right. And so he wanted to build this deck now, okay? And there's, all that space is unoccupied now, and now he wants to build out into it. Could he do that? I think the answer is certainly not. Because, as you said, under the table, you can't build a deck out into a side yard. If Bauman's deck didn't exist now, the space from ground to sky would be unoccupied, and he would be creating this new intrusion into that space, right? But of course, the deck does exist now. So the question now is, with the deck or this obstruction,
let's talk about it that way. With this obstruction now over the ground,
Right.
do we have a yard in existence anymore? Given that part of the structure obstructs the air over the ground.
We are having a very interesting discussion.
Yes.
No, I'm not being sarcastic at all. I mean,
No,
this is
agree
kind
with
of
you.
far
I
out.
very agree with
Yeah. So originally, had in your hypothetical, had the wall gone all the way to the Spillman's wall, and this is a good picture. You were on it before. I think everybody's looking at it. Then we wouldn't have a problem because well, actually we would, because the side lot would be required under the old code. But if we fast forwarded to today, you could build the building, you could build that parking all the way out you could do that, wouldn't be a problem. Okay. I think because you answered, if Bauman wanted to do this today, the answer would be no. I think that necessarily means the answer has to be no with respect to the Goldbergs, and here's why. So if Bauman came today, and let's, again, in our hypothetical world, let's pretend that he owned the entire building, okay? It wasn't divided. And he said, I want to take that deck, the 2006 deck, and run it all the way along the side, the whole run of the side of the building. And would this board say, oh, well, you can do that? I think the answer would be no way. I don't think he'd stand a chance to be able to do that because because what he's proposing to do is further obstruct a yard that has been provided, and I don't think that is the logical basis for the board to okay what the Goldbergs are doing. Just because Bauman's deck obstructed a yard, we believe improvidently, it shouldn't have been permitted, but it's there. That doesn't mean you double down on it and allow and green light every other deck that's going to come down that row. That would completely run afoul of the zoning code. There's no zoning principle that I'm aware of that says you compound the problem. If the current zoning code says there really should be a yard there, it should be 10 feet, I don't think anybody disputes that. Let's cover it up more and more and more with each successive unit owner. That's not the answer. The answer actually is you got to hit the brakes now before that happens, because that's probably what's going to happen. Every other unit owner is perhaps this is the test case, perhaps other unit owners want to do the same thing, and that's just not what was ever intended. And the fact that the Baumans were sort of the first man on the moon doesn't mean that they get to do that. Everybody who follows gets a green light. That's not a zoning principle that I'm familiar with.
I think the area where we sort of typically encounter situations similar to this is where you have a row house and people have a breezeway that extends back some portion and the rest of the house goes. And we've had others where there've been where the house juts in before, but then continues down and then terminates at some later point. And we've had people who come in and say, well, I want to build out this side extension or the side addition to the house, basically covering over top of the breezeway back to the end of the house. So the only real change is, let's say the breezeway goes back 25 feet of a 50-foot house, and they say, well, I just want to cover over I want to build a second floor addition over that breezeway space just to the back of the house. And that typically isn't an issue because they're filling in an already obstructed space, right? And aren't we dealing with that same situation, but although admittedly on a larger scale, because the building is larger?
Yeah, I mean, I'd really have to think, I'd have to think about the hypothetical that you presented, and it sounds like it's maybe not even a hypothetical, it happens, is, I think it's just, it comes down to one of size, scope, and dimension. If we're talking about, a small breezeway, and it's on a single person's property, and they're not taking it down through additional common element, affecting other unit owners, I think that's a different species of animal here. This will be a major departure from what's permitted in the code. And while we're looking at this picture, I think it's important to, I want to, maybe it's not so important given where we are in the analysis, but you see there's a gate there, right? So this all goes to the uniqueness, and the Goldbergs are very nice people. Nothing I'm saying here is meant to disrespect them at all. But all of the the unit owners could get together and say, our address really is Lancaster Street. Let's open this gate and use this gate as the main entrance and not the Thames Street one. They could do it for whatever reason, convenience. They decide to enter on Thames Street. So that's a fact.
There is a curb cut that's there.
Exactly. So that's my point. That this is not really all that unusual. It's a property where the front faces Lancaster. There is actually an entrance off of Lancaster into the parking area. They just happen to lock it off so they don't have to.
That may be the answer to the riddle as to why it's addressed on Lancaster Street.
Well, I think it's always been addressed on Lancaster Street. It's just when. And who knows why they decided to use Thames instead of, but I just wanted to point that out. And also, the gate that we're talking about, Ms. Spillman can explain that that's not attached to the.
No, it is not attached. That was built by the owner of.
Well, I do see that there's a concrete wall under that wrought iron fence. And that concrete wall that the ivy is over top of, looks like it goes all the way to your building.
Yeah, that one goes to the building.
Okay, so that one touches the building.
I need to get her name.
Your name, ma'am?
Annette Spillman.
Can you spell the first name?
Aneta.
Spillman?
Spilman.
Mr. Chairman, may I ask a question real quick? Say a developer came along with a whole lot of money and for whatever reason wanted to tear down that whole building, the whole condo building.
Right.
And they want to construct a brand new building going out all the way to that side lot line, going all the way down. Would they be prevented from doing that? Given that an interior side yard is not required in this district, and the fact that they could build back all the way back and run it all the way down that property.
If they were to do it today, I think
Correct.
that's, yeah, I think that's the answer.
Okay.
No, you think that's wrong?
The answer is no, because it's a C1 district. And the maximum lot area in a C1 district is 10,000
okay.
square feet.
Sure, but
This
the,
property is significantly more than 10,000 square feet, even without the
but they could put.
They could, he's saying you could reallocate the.
Correct, that's
Yeah,
correct. But in terms of that interior lot line, they could build a full masonry wall all the way down that lot line by right. Is that correct?
Except one, and here's the problem is right now, there is a yard required, because if you look at the recorded plat, so this is what's in the land records, and so this shaded area here, here, I'll back up so you can see. This shaded area here, you can see it calls out 10 feet. And also on the other side, by the way, there's a 10-foot yard on the other. So it's not by accident that when they recorded this and created this building, they did provide. They didn't have to originally, Well, actually, they did. That's why they provided,
That's
under the original
They did
code.
then, they don't now.
They did now, they didn't now, but you would have to completely re-record, set up a new deed, a new title, a new plat.
But is
change-
what you're holding in your hand, is that a restriction on the current deed, or is that merely something else?
I think this is the
This is the
declaration.
lot.
Okay.
Yeah.
Okay.
Yeah. Okay, another point that I want to make, and it's a really important one, which is when as soon as construction began, the Spillmans sent a letter to the Goldbergs saying, get a survey. And in fact, in the plans, you'll see the architect who submitted the plans to support the application, there is a notation that specifically calls out that a survey, the contractor should get a survey. Mr. Goldberg happens to be a contractor, so he knows all this stuff. I'm not saying anything that's going to be any surprise. And they didn't do that. And we submitted the surveyor's report that shows that the footings are encroaching on the Spillman's property. So if you approve, I just want, the board needs to appreciate this. If you approve this structure, then you're approving the trespass on.
No, we're approving a land use. I mean, if they're encroaching upon your land, I mean, then that's an issue you're gonna deal with in civil court.
Well, okay, you're allowing an existing structure, and this goes into my.
It would be, if we were to approve it, we would be approving something within the zoning code that we interpreted to be within the code. If in fact it was built on somebody else's land, we wouldn't be approving that. So to be very
Okay, I'm not, thank you for the clarification. I'm not saying you're approving a trespass. What I'm saying is the consequence is they get to keep a structure that currently trespasses.
Unless you went to civil court.
I'd have to do something about it. So, and I think this is another reason why Mr. Veal said, you need to get a variance for this, because this board, if it's going to approve the existing deck, has to determine whether there's hardship, whether it comports with the current historical regulations that apply to this property. And we submitted the email from Mr. Leon that said he didn't appreciate, he just thought a replacement deck was being constructed. He didn't realize it was going to be doubled. And so one of the hardship, if you're concerned about the hardship, and there's really not much of one. The deck cost $4,000, and I'm not minimizing $4,000. It's real money. But all the cases that talk about hardship, they say the cost of taking it down, that doesn't constitute a hardship, and certainly for $4,000, that's not going to be a hardship by any measure. But they're going to have to take it down eventually anyway. So it encroaches. It's got to be removed. And if this board determines that it was improvidently granted, as Mr. Veal said, therefore it should come down. If there's any worry about hardship, well, we're going to be dealing with this anyway in civil court or elsewhere. So it's not a hardship to correct a current trespass. I wanted to.
So I'm clear, how would the deck be a trespass?
The footers are encroach in the Spillman's property. So
I thought that they were in space leased
Yeah, I'm just looking at this lease.
But they're in our property.
They're just saying they were placed at the wrong spot.
Correct. So they're going to have to be moved. They're buried and cemented into the ground. They're going to have to be removed. No matter what happens here. If you're looking for photos.
Yeah, I mean, it looks like it's on the inside of, looks like there's a wall, a masonry wall that goes the length. It looks like they're on the inside of that wall.
And that wall is entirely in the Spillman's property. So outside of the wall belongs to the Spillmans.
Aren't we going a little beyond what we're here for today?
I don't think so. I'm pointing out, when we talk about things like hardship, and we talk about things like, is this a mere inconvenience? I'm just pointing out to the board that this is of their own making. They had the opportunity to do a survey, they passed on that opportunity, and
So that we're clear, the photo that I'm looking at here, this is, I think it's the fourth one in, shows the view from underneath of the parking deck. And it shows the exterior of what I believe to be your client's wall, right there. And then contiguous with that is this solid wall that's here. And you can see the footers are right up against the wall of your, close to it anyway, of the wall of your client's property.
That's the other deck flare. That's not the spill, that's not
Okay.
the gold post.
Okay.
The first deck.
So, and if you
But
exhibit,
the question though is, okay, so taking this in chapters, is this in your client's property?
I do not know. I'd have to look at the report. Is that
Because,
one
I
of them?
mean, the point is that if this is the wall, right, this wall here opposite the parking lot is contiguous with the building wall of your client's house.
Correct.
How would anything on this side of the wall be your client's property?
Because the property extends beyond the wall. So if, and there's if you look at Exhibit G in our submission.
Object to the.
Well, I'm trying to clarify.
I understand that, but if I may, for the record, object to the introduction to evidence of Mr. Dietz's survey. The survey itself says on the face of it, this survey was prepared without the benefit of a title report. And Mr. Dietz is not here for us to cross-examine. While I'd like, and I trust Mr. Schuster's analytical ability, he's not, to my knowledge, a surveyor. So without there is, this is an administrative hearing, I understand that. There is a bit of a bridge too far. I don't believe this is relevant to this board anyway, but I will note for the record that there is no witness here to testify to it. His survey, I can't cross-examine him, and the survey itself says it wasn't based on a title report, meaning he didn't pull all the deeds. So I'm not sure what the value of it is, nor am I clear as to what the relevance is.
No, actually, that was not a nice try. So here's the not having the benefit of a title report simply means when the surveyor is discussing property A, property B, he doesn't know whether property A is owned by the Spillmans and property B is owned by. But his survey is correct as to the lot lines and as to the encroachments.
Well, but,
Who owns it? I agree. The surveyor is saying, I don't have the benefit. I didn't go back to the title record.
I think his point, though, is a little bit larger than that, wasn't it? That the result of the survey is the product of his work. Some analysis, some computation, something he did to produce that. And Mr. Burgunder is pointing out that he substantively objects to the survey because he thinks it wasn't properly done, and it's compounded because he can't cross-examine the producer of the survey as to what they did or didn't do in order to produce it. So I think he, in fairness, has a point there. It might be different if the person who produced the survey was here. It also might be different if we were talking about something that was a public record. So if you're going to show me a boundary line on a tax map, something that's recorded, et cetera, that would be one thing. But here you're talking about a product that was derived for the specific purpose of the current dispute. And without the benefit of that witness, I think that it would sort of put them behind the eight ball. That would be unfair.
They wouldn't be behind the eight ball had they gotten their own survey, and we wouldn't have had to go get a survey.
But they're not the proponent of the evidence, you are.
Yeah, but their own document, again, we don't have the architect here I don't have their architect, which was submitted the plans and drawings. I can't cross-examine that person, but that person said, you got to get a survey before you do the work. It's the responsibility of the contractor to get a survey. So, look.
But there's no product that he's sought to admit that is the benefit of someone else's work is out here.
I think in the relaxed evidentiary standards that apply to administrative hearings, this board can take and apply whatever weight it deems appropriate to a stamped surveyor's
That might be true, but you're also, to Mr. Bonaventure's point, talking about something that's fairly tangential as far as the argument that this was some sort of a trespass. I was looking to see if there was some kind of record in existence, i.e. a tax map, et cetera, which would show a boundary line and an encroachment of this into that space, or if you got a photograph which showed, here's the wall and the footer is located beyond that wall, that would be something. But if it doesn't sound like it's that clear cut. It sounds like you're making some argument about her property line actually being on the other side of that wall.
That's true.
And then you get into issues with, I'm sure the condominium association would raise issues of adverse possession, all ancient boundaries, et cetera, et cetera. So, and those sorts of things aren't before us. So the point, I think, is a fairly marginal one. So
okay. The other point that I'd like to make is the Goldbergs asked the Spillmans whether there'd be any objection to this, and they replied, and this is in the record, that there would be an objection. And I think this is important. It was the neighborly thing to do. I'm not criticizing that for that. What I'm saying is, you don't have to ask if it's permitted, and you have every right under the law to build a deck. There's no need to ask permission or ask, and I think that's a recognition that they knew they were on the edge here. They knew they were doing something, because and I wouldn't say this of a lay person, but Mr. Goldberg is an experienced contractor in Baltimore City. He knows that this was a side yard. He knows that there wasn't a deck permitted, and he was hoping to get permission to avoid that. And so I want to make sure I point that out.
Counsel, didn't Mr. Goldberg ask if there would be an objection, not whether may I do this?
Well, let's look at
different, isn't it?
Let's look at the letter. I mean, I'm trying to be again. I have no animus whatsoever to the Goldbergs. I think they're nice people, but the letter.
And did you have an exhibit packet, by the way?
It was submitted before. I hope.
Oh, okay.
I have extra copies, though. Can you get me?
Yeah, if you've got extra copies, that'd be good. Because I think that we have a large one that's in the main file, but we individually don't have.
The letter.
No, this was from Mr. Burgunder.
Yeah.
This one.
So here, I have got copies. All the exhibits are attached.
Okay, that's great.
And can I just hand them up?
Yeah.
And then I do have a couple other exhibits I want to present. I'm sorry, I would have done this at the very beginning.
That's okay. Okay, very good. I can give one to Trip.
And here's a copy of thanks. Here's a copy of the March 26th email from the Spillmans to the Goldbergs, asking them to get a surveyor. I want to just make sure you see in response to Mr. Fields' question.
Thank you.
Okay. So this is Exhibit C in the materials that I just handed up, and it's attached to my June 19 letter. And it's the email exchange where Mr. Goldberg asks, he's following up on a conversation about the deck and is asking, I hope you've been able to give this some additional thought as we'd like to get started on this project in time for spring, summer. As our neighbor, it's important to me that you are on board. And I think I characterized it as they wanted to make sure there was no objection, and there was an objection.
Wasn't that what Mr. Fields' point was?
Yeah, as opposed to permission, he's saying, would you have an objection?
Yeah.
We'd like to avoid an opposition at a zoning. Perhaps that's what he meant, as opposed to, if I get your permission, well, that, I won't have to do anything else, because they did then go do everything it appeared they needed to do, got a permit, got the authority, built it, right?
They got the permit. That's why we're here. And this is not meant to
I understand.
to disparage the Goldbergs at all. But as soon as it was brought to their attention by Mr. Veal, had a conversation with them, there was a stop work order on April 4th or 2nd, and they continued to build out the deck. And I mean, we have, and I can, the railings weren't there in so let's see here. Yeah, so, you can see, this is a photograph, and I'll ask Ms. Spillman to authenticate it.
Yes.
Is this a photograph taken by you on
April 11th.
April 11th? And it shows the deck is still under construction.
Correct.
And was that after Mr. Veal's office directed the Goldbergs to stop construction?
Yes.
Objection. It's hearsay. It's called having Spillman tell us what Mr. Veal said.
Okay, well, then.
Is there a stop work order, a printed stop work?
I've got here, it's a verbal. I've got an email from Mr. Shahid, who corresponds and says they were told to stop. It was a verbal stop work order, and I can hand that up as well.
Who's Mr. Shahid?
He's the inspector. And I'll ask Ms. Spillman to authenticate this. And is this a copy of, can you read what Mr. Shahid wrote to you on April 4, starting with good afternoon at the top of the page?
I met with the owner contractor this morning, measured the deck and reviewed the approved drawings. In terms of building inspections, the deck is built to code. I did give the owner a verbal order to stop work until he meets with the zoning administrator and the determination is made if it's legal.
I'm sorry.
Determination is made if he can continue to build the deck as permitted.
And that's on?
That's on April 4th.
Yeah.
And Mr. Veal was copied on all of this communication.
And of course, Mr. Veal is the one who said, and I put this in the letter, that if you don't seek a variance, I'm going to revoke the permit. So that's what the Goldbergs were facing. I mean, to his credit, Mr. Veal recognized that the permit never should have been granted, and that's why he said you need to go get a variance, and that is why we're here. If the question is a variance even needed, the answer is yes. That's why the Goldbergs filed this appeal at the direction of Mr. Veal, who said you got to get a variance, or if you don't, I'm revoking the permit, which would be a result that obviously the Goldbergs didn't want to have happen. So that's why we're actually here. So I don't think there's a question that this board needs to decide whether there are sufficient grounds for a variance. And on this record, I I don't think there is sufficient evidence. There's really no evidence to show that this essentially is a minor inconvenience. No one's saying they can't have a deck. They're going to have a deck. But the footprint is going to be their existing deck. So the question isn't, are they being deprived of any great use of their building? They're not. They're going to have a deck. It won't be as large as the one that they had hoped for. But that you check the box on the inconvenience side of the ledger, not the hardship side of the ledger. This is not a hardship to ask them to restore the deck to what its original footprint would be. And I know I don't want to wear out my welcome at all. I know this has been a long day for everybody, but I do want to have Ms. Spillman just talk about the effect of the deck and why she opposes it and how it affects her use and enjoyment of the backyard. So,
Sure, thank you. Our counsel, I think, very skillfully presented the case that a variance should not be granted in this particular case. Also, we need to perhaps address the issue that the way this deck is built causes a tremendous hardship to us in terms of maintaining our wall of the house, which it becomes absolutely impossible for us to maintain our wall. That's all in your exhibits. Nor can we have workers even use a ladder there, so that's an important thing. Plus, it's injurious to us in terms of the enjoyment of our garden. And my husband, who has owned the house since 1983, and myself for the last 20-some years, we have opened the garden to so many nonprofits in Baltimore City, starting from Chinkapin to College Bound Foundation to you name it, for functions. And this huge encroachment, which is not allowed according to the zoning code, should simply, we feel, not be allowed to continue, and the deck should be brought back to its original site. Also, according to the CHAP guidelines, and when you look at the site of line and the whole building and the 6 townhouses which are part of this lot, CHAP and Eddie Leon confirmed that the guidelines calls for everything to look alike. When you look at this picture, all the other decks are the original size, which is what was allowed back then, 7 feet projection, not 16 like this one is. They all look alike. According to the Baltimore City guidelines and CHAP guidelines, you want to maintain the sight line, the line of sight, and you want to be consistent. Everything is with vertical railings. This one is with horizontal, which is absolutely not something that anyone had in mind. So no matter how you look at it, it's not to mention about all the cars which are parked underneath the deck. And that creates an issue. I heard all of your arguments about can they bring the building there, can they bring the building here, but we also have to recognize the fact that you have 4 cars parked underneath, right next to our property, and that's a huge hazard as well. And it's not 4 cars, it's 4 plus 4 plus 4, 4 plus 4.
I saw one of the pictures prior to the deck being built showed those concrete parking barriers, where you pull up and that's as far as you can go. And they were very close to your property line. So it appeared that cars were parking there prior to the deck being built. So I guess I'm a little curious, what's the difference?
When the whole thing is closed up, if you do that, that's a fire hazard, because then you need to have, according to, and I'm not an expert on zoning code or fire code, but that's one of the things which is brought up all the time. The gate towards Lancaster Street cannot be locked because you need to have access to it, ingress and egress, which it is. And also you cannot park 4 cars under a deck. That does not have the board which you have to build, and it becomes an enclosed, all of a sudden this open parking lot becomes an enclosed parking lot. That is my understanding.
Okay.
So there are so many difficult issues here that are coming into play, in addition to what our council said, the encroachment on our property and everything else, and actually the damage to our property, basically.
And something else you said, I just want to follow up on. You said there would be difficulty maintaining your property because of the deck?
We cannot access the whole wall of our house, the side wall of our 3-story house.
How did you access it before the deck?
There was room there when we have to maintain it. Here's the picture. This whole wall here.
Oh, that wall. Okay, I'm sorry.
We
I thought you meant your
No,
okay,
no,
okay.
not the small thing. We're talking about the whole 3-story wall of our house. We have no access to it whatsoever forever,
Well, how
if
did
you
you
allow
have
this
access to
to
it
happen.
prior to that? Because to have access to your wall, you'd have to go on condo property.
Right.
Permission.
And we have Mr. Kausi, who is the owner. We've had a very good
Okay.
working relationship both ways. So now it becomes physically impossible for us or for any worker to put a ladder or anything. There's no room between the house and this deck. And for us, that's, I mean, talk about marketability of our house, but talk about us being able to maintain our property, for which we've worked very hard all these years. It just, none of this makes sense. And the encroachment, according to the zoning code, I understand you can make all sorts of arguments. Well, but what if this, what if that? But it is an interior side yard, and it says deck is not allowed to be built in an interior side yard, period. And all your arguments, and I fully appreciate that, oh, well, what if they want to extend the whole building and all of that? But that's not allowed either in a C1 code. You can't do that because you are limited by the size of the building and what you can do. So that's, I don't think that's relevant as well. And I just feel, and we urge the board to do the right thing and let us enjoy our property and not allow this to continue.
One question, or maybe two. You mentioned about the gardens and how you use it various ways up to now. How do you access your rear garden? How do you
Through
access it?
our house.
Through your house or
Yeah.
coming in the back, right?
No, from our house.
For Lancaster
There's no
There's a Sally Port.
back. It's we have a sally port, we have a garage and doors. We can show you a picture of the garden. It's from our door of the house.
Okay, there's
Your name
no,
For the record, sir?
sorry.
Your name for the record?
C-R-A-I-G,
Spillman.
C-R-A-I-G, Spillman.
Here is one of the doors of our houses here. And this is the garden is right here.
So you still have the same access
To the garden, yes, we don't have access to the wall of our house, the three-story wall of our
One of the
house.
things you mentioned was we can't use our gardens the way we did.
Well, this encroachment, if, I wish you could see it, this overhangs in our garden, talk about privacy, talk about.
It doesn't overhang over your
Well,
garden,
it's
right?
right there, it's on the line, there is no light coming from here. There's nothing, it's just,
Okay, one other question, this may be for you, counsel. Do you intend to proceed against Mr. Baumann?
Haven't decided yet. Haven't decided. I just, I want to urge the court, I think, the panel, I really think it's a distraction to read anything into what may or may not have happened with respect to the Baumann deck and use that as a basis for doing something with this application. What arrangements the Spillmans may have with them, Mr. Chairman urged parties to talk, and we tried to do that in the hallway. But whatever, it's completely irrelevant what is going on with the Baumann property and the Baumans as neighbors. And I think I said this, and I apologize if I sound like a broken record, this is where I really will end. The zoning code, it's a dangerous step for this body to decide that that clears the way for any other structure to be put, because we're not only talking about decks, we're talking about anything now that can go into that side yard where that chart doesn't check off very much that's permitted in that side yard. And so by using that as sort of the snowplow to get to approving this application will open the door for any encroachment, because that analysis doesn't end with decks. It ends with any encroachment if it's true that yard disappeared and was rendered gone when the Baumans did what they did.
So is your position that because a side yard was provided, that it's necessarily required?
It is, yes, it is now. It's required. It was required originally before the zoning code changed recently, and because it's provided, it is required. So no matter how you cut it, it's a required yard.
Thank you. Mr. Burgunder.
Yes.
Sorry.
Very quickly.
You can use the microphone.
I know it's late. Very quickly, because I know it's late. Two things. We don't need to deal in hypotheticals. We have a set of facts before us. The facts are very clear. We don't have to worry about what Mr. Baumann may have done. We're not here to relitigate that. It's from 2016, and as the Spillmans testified, they've lived at that place, in that house, enjoyed it from well before 2006. When Mr. Baumann got his approval. The point of the matter is that we're in a C1 today. There is no side yard, and there's no side yard required. And look, I appreciate the fact that the Spillmans would like to make this about something that it really isn't. They're worried that people down the line may do something in the future. We're not here about other people. Those other people aren't here. We're here on our application. To suggest to this board that you should deny us because somebody else might build something in the future is really immaterial and irrelevant. The bottom line is
It really is in for a penny, in for a pound, isn't it, though?
Well, I understand that, but that was...
The question is there a yard provided? If there's a yard provided, then there's a 10-foot requirement.
And
If there's
there's-
not a yard
correct.
required, if there's not a yard provided, then build whatever the heck you want, whether
That
it's
is true, and
yours or whoever else.
And while hypotheticals are not entirely, I think, relevant to the decision, Mr. Baumgartner's is if you tore down the building, you could build. This is Baltimore City. This is not the suburbs. This is not, out in the country. People have row houses, and they touch up against the line. So if you rip down the building, of course, you could build it right to the property line. Obviously, you couldn't violate lot coverage requirements and things such as that. But if somebody wanted to do that and had all the money in the world and that's what they wanted to do, they could absolutely do it. And the point here is that there is no side yard. It is obstructed in several ways. There's a brick wall that goes all the way to the Spillman's property. There is a wrought iron fence. There's a deck that has been there since 2006, and there is no, the code is pretty clear. I don't think there's much of an argument there. No one's looking to turn the zoning code on its head. I mean, think about it. My clients reached out to the neighbors and said, what do you think? That's what people should do. This board encourages that to create a negative inference when somebody does that would be the opposite of what this board always says is, and what I advise my clients is, talk to the neighbors before you do anything. That's what ought to be done, and that's what was done. They didn't ask for permission. They asked for their support. Obviously, they wouldn't have had to come to a hearing. They wouldn't have had the pleasure of my company for all these hours as well. So I think that's a good plan. I don't think the board should do anything to discourage that. There is no such thing as an interior condo yard. Each condo doesn't have its own yard. So once that yard is gone from Mr. Baumann's deck and the brick wall, it's gone. So therefore, there's no interior side yard. Mr. Leon's comments, I'll just address briefly, they were all based on a misunderstanding about whether the neighbor had gotten approval. So I think you really have to discount that. He was also giving, I think, frankly, zoning advice, which is outside the CHAP purview, but CHAP approved it. It's not, this building itself is not historic, but it's in a historic district. They sought and received the CHAP approval, the notice to proceed, which they were required to do. With regard to the continuation of the building of the deck, it was a verbal. I will proffer that Sarah Mandel talked to Mr. Veal, who said, gave them permission to complete it for safety purposes. You can't leave the thing out there without a deck, without a railing on it, just in case anybody went out there, and they did it with permission from Mr. Veal. With regard to whether we're here for variance, our application did not seek a variance. We're here, the application very specifically said that we are here to retain the deck properly built onto that permit. We'd ask that that's what you do. Mr. Veal's letter, while the opponents do like some of the things Mr. Veal says, they don't support some of the other things he said, which is Mr. Veal said approve the continuation of this deck. And finally, lastly, I will say this, and I think it bears mentioning, with regard to the survey and the maintaining of the wall, There is a concrete block wall that separates the Spillman's property from the condominium property. And even if Mr. Dietz were here, it says that the block wall that is.
Or do you want to go down that line?
Well, I don't want to. I'll leave it alone, but there is no, you'd have to trespass to go maintain that wall in any shape or form. At best, it's a 2-inch difference, so I don't believe it's relevant. At the end of the day, it's a C1, the zoning code's in effect, there is no side yard, and we believe that this board should approve retaining the properly built under the permit with the neighborhood and the condominium association approval and CHAP approval. We'd ask that the board support that request. Thank you.
Thank you. Thank you both.
Thank you for your time. May I ask a procedural question? Is it still the board's intention, given the hour, to take a vote tonight?
We probably will, yeah.
Okay.
Yes. But,
The day is young.
Early for us.
yeah, seeing as how we've been here till 9 before,
Yeah.
I'm not looking to do that. We had one no-show, right? One more time.
Watch yourself.
Which one was that?
I have these notes. Take an opportunity to do that.
We have 2018 195 3420 Ravenwood Avenue, Mike Feliciano. Okay, no. All right, and we're off the record. Ah, yes. If anyone wants to